Good afternoon and welcome. This is a regular meeting of the Sunshine Ordinance Task Force, called for Tuesday, September 22nd, 2009 at 4 p.m. and starting at 4:05 p.m. May we have the roll call, please?
Yes, Mr. Chair. Member Craven Green? Here. Member Craven Green, present. Member Lee?
Here.
Member Lee, present. Member Colton?
Here.
Member Colton, present. Member Washburn? Member Washburn, excused. Member Caneva?
Here.
Member Caneva, present. Member Johnson? Member Johnson, excused. Member Chu?
Here.
Member Chu, present. Member Chad?
Present.
Member Chad, present. Member Goldman?
Present.
Member Goldman, present. Member Williams?
Here.
Member Williams, present. Member Manny?
Here.
Member Manny, present. Member Chair. Mr. Chair, we have a quorum.
Thank you. First, I'd like to bid a welcome to our newest member, Suzanne Sane. She has not actually been sworn in, so she will be sitting at our table today as a non-voting member. However, during the course of discussion, we would certainly welcome her thoughts and comments. Are there any changes to today's agenda?
If I may.
Please approach.
Thank you so much. Good afternoon. I'm with the San Francisco Arts Commission, and I'm here to speak to item number 15 and 16. And my only request would be that I have a community meeting scheduled at 6. So
Are you a party in interest to the item?
I'm,
You responded.
yes.
You're the respondent?
Yes, I am.
Okay.
I just
Okay,
was
so
hoping I could.
15 and 16 moved up.
That'd be great.
We'll see if we can accommodate. We do have some similar requests from another party, so.
Okay.
we'll see if we
I'm
can-
happy staying for a couple of hours, but I do have to be out in a...
Understand.
Thank you.
Thank you. And I believe we've had a request from Mr. Warfield to move up his complaints, items 21, 22, 23, and 24. These are case numbers 09056 and 09057, both of which involve complaints against the clerk of the board. Are there any objections on the committee to moving these items up? Seeing none. What I will do then is okay, items 15 and 16 will be moved up past items 4 and 5. And items 21 through 24 will be moved up just past items 15 and 16. So we'll have, after item...
Point of order, please. 15 is, the person that filed for 15 and 16, it seems as if all 6 of those items should be lumped together. I don't see why the 14, 15, and 16 should be put forth unless all...
Well, sir, the person asked only for 15 and 16 to be moved up.
That person is...
That person is a respondent to a complaint.
You respond to that?
To 15 and 16
For
of
the coaches, sir?
Yes.
Thank you, sir. Okay, so after item number 5, we will hear 15, 16, 21, 22, 23, and 24, then resume with item number 6. We all on the same page on this?
Yes.
Good. Mr. Clerk, you read the first item, please?
Item number 1 is the approval of minutes for August 25th, 2009.
Members, I just have a couple of typos and whatnot. I'm just giving them to Chris. Nothing substantive.
Okay, any other comment on the minutes from the task force?
Motion to approve as amended.
Second.
Moved and seconded. Is there public comment on the minutes? Seeing none, before taking the action, I would like to note that I have looked through the minutes and have found a number of corrections that are needed. I will be emailing those to the clerk. they're substantive. Further comment? Roll call, please.
On the motion to approve the minutes, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cotton.
Aye.
Member Cotton, aye. Member Washburn. Member Washburn, excuse. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson. Member Johnson, excuse. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Lee.
Aye.
Member Lee, aye. Mr. Chair, we have 8 ayes.
Okay, Mr. Clerk, could you read the next item, please?
The second item is the determination of jurisdiction on the complaint filed by Peter Warfield against the Library Commission.
Okay.
Members, I move that we find jurisdiction on this item.
Second. Moved and seconded. Is there comment on the motion? Okay. Is there any public comment on the jurisdictional matter only? Seeing none, Mr. Warfield, you are part of it?
Is there not to be the usual presentations?
Yeah, we're voting now only on jurisdiction.
Is
The
there not a
the merits of
presentation
the
on
case,
jurisdiction?
the merits of the case will follow.
I thought that the procedure was to have a discussion by both sides on the question of jurisdiction, which
If
I
juris-
don't contest. I'm happy with
If jurisdiction is not being contested, we have no discussion. There's nothing to discuss. Okay. Seeing no public comment, task force, no comment, roll call please on jurisdiction.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cotton.
Aye.
Member Cotton, aye. Member Washburn. Member Washburn, excuse. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson. Member Johnson, excuse. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Lee.
Aye.
Member Lee, aye. Mr. Chair, we have 8 ayes.
Okay. We now move to the merits. Would complainant please approach the microphone? Thank you for coming. You have 5 minutes.
Thank you very much, Mr. Chair. I'm Peter Warfield, co-founder and executive director of Library Users Association. What we have here is a very problematic, a very unfortunate incident, except that you have seen an example of it in July in a previously filed complaint by another person. Freedom of speech in our country is a very significant and important thing, and it's certainly protected in a variety of ways by the Brown Act and the Sunshine Ordinance. In this instance, I'll just briefly read my rather brief complaint. At the meeting in the Library Commission, which had Park Branch Library peer review discussion on the agenda, we attempted to make public comment under the general public comment portion. And that comment was on another subject entirely, and one that was within the purview of the Library Commission. The president of the Library Commission interrupted us repeatedly, preventing us from making the intended and the announced comment. We then went on, realizing we would not be permitted to speak on the subject intended, changed the subject and talked about something else entirely. So first of all, let me read the public comment agenda item as it was on the March 19th agenda of the San Francisco Public Library Commission. Number 1, public comment, then parens. This item is to allow members of the public to comment generally on matters within the Commission's purview, as well as to suggest new agenda items for the Library Commission's consideration. This is not in your packet. There is no restriction here stated with regard to whether or not matters that are taken up elsewhere in the agenda may or may not be addressed. It simply says that members of the public can comment on matters that are within the Commission purview. And that's exactly what I tried to do, but was repeatedly, and by my count 5 or 4 at least times, was interrupted by the Commission President. Is there a timer here? Am I missing it?
Mr. Russell?
Mr. Chair,
The
count is,
gentleman asked for time.
it's 2:20.
Item 2 on the agenda placed the library discussion of anything to do with Park Branch within the bond program manager's report. And it said, item 2, bond program manager's report. This is a discussion item to allow the branch library bond program manager to report on recent bond program related activities and make announcements. This report will consist of an informational presentation, none. Regular reports, program budget, schedule, and construction reports, active projects, and community outreach, and special reports, Park Branch peer review response. Now, under that, one might have expected that there would be a report by the bond program and that that would be something upon which the public might have an opinion and discuss. Also, the branch peer review had been something that had happened in February, and that also is a very specific incident. And one normally wouldn't be expected to make broad comments on the Park Branch generally. So here is what happened at public comment, which in any case did not restrict to anything other than what's within the commission purview. And that's the end of the previous speaker.
Public comment? Thank you.
Yes, Peter Warfield, Library Users Association. Later on, we'll be talking about a lovely old library that's airy and spacious, high ceilinged, open rectangle, the Park Branch. I would like to talk about the process by which the changes or the renovation planning has proceeded.
This is for general items that are not on the agenda. That will be on the agenda later.
The
Thank
process
you.
by which
That will be on the agenda later. The Park Branch will be on the agenda later.
The
You
agenda
can talk about
says
it then.
the
You
process
can talk
is
about
what
it
we want to
then.
talk about.
You can talk about the Park Branch then.
The library has violated sunshine on my requests.
Having been interrupted 5 times, I basically changed tack and spoke about general sunshine issues with respect to the library and the many violations and so on and so forth, rather than the specific violations that had occurred and the problems that had occurred with the process of planning the Park Branch renovations. And that was the silencing of a particular issue that I wanted to speak about. Is that my 5 minutes?
Yes.
Thank you.
Thank you, Mr. Warfield. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, would the respondent approach, please? Thank you for coming. Please identify yourself. You have 5 minutes.
Joel Gomez, President of the San Francisco Library Commission. We've been doing the renovations of the libraries in the program for at least 4 years. We have a series of processes that occur for each library, each of the 24 libraries. They have not changed in 4 years until recently. And in that process, when the library is on an agenda item, any topic related to the library is allowed, which I did indicate when I asked the complainant to stop speaking and save it. I indicated he would be able to have that conversation when we got to the Park Branch Library. The opening comments from the public are generally reserved for things that are not on the agenda. This has been true since I started on the commission 4 or 5 years ago. It has not changed. I'm not sure why the complainant thought that there was some change. One of the reasons we divided in that way is because members of the public come to respond, many members of the public who are not regular attendees at the meeting. I would prefer them to have the opportunity for their 3 minutes rather than have 3 minutes at the beginning and then 3 minutes again on the agenda so that we all have a chance to speak. This is something that the complainant should understand clearly. He speaks for his 3 minutes on every agenda item except adjournment at every meeting. So I'm not sure what the confusion was. When I asked him to not speak on the park branch, he switched to a different topic and completed his public comment 3 minutes on a different topic as was appropriate. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Thank you for coming. You have 3 minutes.
Hi, I'm Sue Blackman, Library Commission Secretary. I just wanted to support the comments of our President, Joel Gomez. It has been a very clear policy with the Library Commission that when items are on the agenda, they are very broadly interpreted to anything relating to that branch, specifically within the book program, which would include the process of community outreach. And again, Mr. Warfield did continue with his 3 minutes, so he did have public comment and then again spoke under the item on the agenda for 3 minutes. I would also like to say, Mr. Warfield, this is not a case that is just before the Library Commission. At a recent Historic Preservation Commission meeting, the same action took place where Mr. Warfield tried to speak on an item that was on the agenda, and the president of that convention also did not let him go forward with his comments. So I just want to say this is kind of a recurring thing, and I support our president.
Thank you. Is there anybody else to present facts and evidence in support of the respondent? Seeing none, the matter to the task force. I have some questions. Mr. Warfield, please approach the microphone. In the agenda item, with respect to the Park Branch Library, what did the agenda say about what was to be discussed about the Park Branch Library?
There were 5 words following special reports, colon. And the 5 words were Park Branch Peer Review Response. It did not say a discussion in general about the design of the park or anything about the park other than a response to a peer review that had happened in February. It was rather convoluted, and one might have interpreted it very, very narrowly.
Okay, so the peer review was really what was on the agenda there.
Peer review response.
Peer review, and what did you attempt to speak about?
It was my attempt to speak about the process by which the renovation had been moving forward. And in particular, I was extremely concerned about some background which I wasn't able to give you here, and that was in the immediate preceding 2 weeks, basically, the library had denied me access to the Park Branch plans, the most recent plans, which you found 8-0 was a violation of Sunshine and of my rights to follow what was going on with respect to Sunshine. I wanted it understood what was going on behind the scenes to cripple the discussion and the understanding of the public with respect to what was going on. There's another thing that was also going on in terms of background, and that is that the library was, one might say, juking the numbers so that they had one...
Mr. Warfield, I think you're going a little bit astray here.
Okay, there were violations that I wanted to talk about.
But you did not want to address specifically the matter of the peer review response.
I certainly did. In 3 minutes, it's not possible to talk about all of the issues.
But I mean, during general public comment, when Ms. Gomez silenced you, you did not attempt to speak about the peer review response?
Certainly not, because she was telling me that already what I was saying was on the agenda later, and that that's when it would be appropriate to speak about it.
Thank you.
So,
thank you. Member Kaufman.
We have had a case like this before. Peer review, I go to all the commission meetings, so I know the custom and practice. Peer review means they get in an architect, they get in a librarian, they make comments on the design. So peer review is an analysis of the design. Now, since they had the peer review the month before this particular meeting, which was in March, they had they now have the peer review response. So I'm assuming the peer review response is from the library. They're going to say how they respond to the architect and librarian's peer review. So that's a very specific item. I think if Mr. Warfield was trying in the beginning to talk about some other aspect of the park library, he said he wanted to talk about the process and what was involved in the planning. In fact, under public comment for that meeting, it does not say for items that are not on the agenda. It just says items that are generally within the purview of the Library Commission. After another case in which there was a public comment denial, the library changed their agenda item and they put in general public comment on items within the purview that are not on the agenda. So I think there are two reasons here why there has been a violation. One, public comment as construed in this March 19th agenda, which I have with me and can pass around, it actually permitted general public comment. The item about the park library was very specific. It was a response to a peer review. So in my opinion, Mr. Warfield's attempt to speak on another item at the beginning was perfectly proper. In fact, if he had tried to speak about the peer review, something other than the peer review response, he could have been ruled out of order according to the way the agenda is.
Thank you.
I'll pass it around. Yeah, I'll pass around the agenda for the meeting, then the agenda for the meeting where there was another case of public comment, that was June 4th, then the June 18th agenda where they finally say general public comment is only on items that don't appear on the agenda, so I'll just pass it around.
Chairperson Lee, I think before, this should have been given to Chris, so I knew a city attorney could have seen it, as well as to advise us. I know we have Erica, but I think our city attorney should have seen it also.
Well, there's nothing to prohibit us from looking online and getting it ourselves. It's
But I still believe that our city attorney should have seen it.
Yeah, it doesn't require any particular legal analysis. It's just that, I think Ms. Gomez read it to us. It just was hard to catch it while she was reading it to us. I think the issue here is, I think it actually is reasonable to limit general public comment to items not on the agenda, even if general public comment does not so denote. That's policy and practice, I think, of most bodies in the city. So even though this agenda didn't say excluding items otherwise addressed on this agenda, I think it's appropriate to do so. And it's appropriate for the chair to let someone know that that issue might be addressed in the next item. I read item number 2 as being very broad, actually, not very narrow. I see, to me, the problem is item number 2 encompasses a lot of different issues, right? If someone's supposed to be able to get up in item number 2 and talk about the renovation of any of the libraries, but also the Park Branch peer review response, which is just a special report, which is one of the items included, not the totality of item 2. It's just one of the items in number 2. 3 minutes may not be that much time to respond to all of those embedded issues, but that's the way the agenda was drafted. So I really am not particularly persuaded that there's been a violation here. Would it be better maybe for the library commission to not cram so many items into one agenda item? Probably. That would allow people to have more public comment on issues that are of grave concern and people are very motivated about, but I'm really not sure there was a violation.
Would you pass that around, please?
Sure.
Yeah, I'll just comment again if nobody else wants to talk. I think the fact that the Library Commission in general public comment did not specify that it had to be about items that were not otherwise on the agenda. They simply specified it was any item within the purview of the commission, and the fact that they later changed it to specify that it could only be items that weren't elsewhere on the agenda indicates what their intent was, but their intent was not codified until June 18th, and this is the meeting of March 19th. Secondarily, the second item, which is, I guess it's the Branch Library Improvement Program report, in which they have the response to the peer review of the Park Library. That's a very narrow item. As I said before, it's a response to an architect and a librarian who came in the previous month and critiqued the design. So it's about the design and how they wanted to tweak it. And then there is the library response, which was under item 2. So in my opinion, had Mr. Warfield tried to talk about the early process and the planning, he could have been ruled out of order, since the peer review response, as I said before, is the response of the library to what the architect and librarian suggested about the design.
Before we go any further, I wish to apologize for a little bit of a lapse. I want to introduce another member of our team, and that is our new Deputy City Attorney, Jerry Threet, who is sitting to your left, my right. And Jerry has been named to replace Ernie Laurenti, who worked with us for, I guess, pretty close to 10 years. And Ernie did a terrific job. Jerry, you got big shoes to fill. I will say that there were times when we disagreed with Ernie's interpretations of Sunshine Law and how they applied, and we expect it's probably going to happen with you as well. But Ernie worked very hard, gave us some valuable information as we move forward, and we look forward to working with Jerry Threet as well. So welcome aboard.
Thank you. I'll just say that I look forward to working with you all as well.
Okay, now is there further discussion on this among the task force? Seeing none, the matter is open to public comment. Is there public comment on this item?
Ray Hartz, and I'm going to say something I actually find myself surprised. I agree with Member Coffin. Mr. Warfield tried several times to make it clear that he was trying to talk about not the specific item on the agenda, but the process by which that item got there or whatever. And I was an instructor for a number of years, and what I would do is I would always sit down and I would say, okay, what is it I want to teach people? What is it I want them to learn? And then I would sit down and say, now, what is the best way to do that? Those are completely different things. And I think that what Mr. Warfield was trying to do, from what I heard the tape he played, was to simply say, well, yes, that item's on the agenda, but there's something about that item and how it got there that I don't approve of. And I agree with Member Coffin that if he had started to talk specifically about that item, then yeah, that would have been double time, whatever. But the bottom line is, I see a real tendency sometimes of city agencies, commissions, task force, whatever, to stifle freedom of speech. The bottom line is, when I stand up here and I have my 2 minutes or 3 minutes, those are my 3 minutes. Nobody has the right to tell me not what I can't say. You may have the right to respond to what I say, to disagree with what I say, to decide against what I say, but you don't have the right to stop me from saying it. What did Voltaire say? I may not defend what a man has to say, but I will defend to the death his right to say it. If there is going to be an error in public government on by a commission, a board, whatever it happens to be, the error should be let them speak, and if you don't think it's right, then disagree with it. My freedom of speech does not extend to stifling the freedom of speech of other people, and that's exactly what was done on this occasion.
Thank you. Is there further public comment?
My name is Francisco da Costa, and it's been many years since I have been observing and hearing about how the San Francisco Public Library conducts itself. Mr. Warfield is an intelligent person, and as one of your members pointed out to y'all, when I think most of y'all really were not very clear as to the language on that particular agenda item, one of your members pointed out very clearly to y'all what peer review means. Now, I work for the National Park Service, where that language is used. And that language clearly specifies opinions from an expert, which, as your members stated, happened in a previous meeting. So, Mr. Warfield, if anybody comprehends English, and I suppose that's the language of the agenda, had every right. They're not talking about legalese. They're talking about plain English. E-N-G-L-I-S-H. Not German, not French, not Kiswahili, or any other language. In my opinion, having heard the deliberations today, Mr. Warfield had every right to speak. And if you, in your adjudication, say otherwise, I will be baffled. Thank you very much.
Thank you. Is there further public comment?
Good evening. My name is Ace Washington. As an observer, just sitting over here listening to Mr. Warfield speak, I agree with him totally. I don't know how many of y'all go to commissioner meetings or community meetings where the sunshine takes effect. We as community people are often stopped in our 3 minutes. Often, all the time. So I agree with this gentleman here. If freedom of speech, if we get 3 minutes, let us speak 3 minutes. Let me give you a prime example. If you look at the board of supervisors, you have a guy come up there and start singing for 3 minutes, and you let him sing for 3 minutes. And you even write articles about it. So what in the hell is good for the goose is good for the gander? So y'all gotta listen to this man because what he said is true. Because number one, in our community where I come from, we're often treated like that, even worse. Without a doubt, we get there to speak, we cannot speak, we are stopped in the middle of our 3 minutes, and I got years of tapes to come to show you what goes on in the Wild Wild West. But I'm here committed to this man here, because without freedom of speech, myself, that's been in this community for years, couldn't get up here and speak. Even at the board of supervisors, today, at redevelopment agency, today, we have been thrown out by police. They got special buttons back there. Every time we get up, they got their finger on it. If we say something wrong, they ready to call the police. So our constitutional rights depends on what you do with this gentleman right here. And if you do that, hey, we might as well, the community and everybody else, let's close it up. Because therefore, you guys got a dictatorship around here. And I'm appalled that if y'all want to go to see what goes on at some of these commissioners' meetings, go to redevelopment. Start going to the board of supervisors coming up when it comes to African American issues. You'll see how we're treated in this Bill of Rights.
Thank you. Is there further public comment? Seeing none, public comment is closed. At this time, the respondent and then the complainant will have an opportunity to make any concluding remarks or rebuttals. Ms. Gomez, Ms. Blackman. You have 3 minutes.
If, as Ms. Coffin says, she attends every commission meeting, I think she will recall that when an item comes up on the agenda about the library, a library, you get to speak on anything having to do with the library. It is not simply restricted to that particular thing, such as a peer review. That's been the tradition, as I stated earlier, ever since I've been on the Library Commission. I attempted to reassure the complainant that he would have the opportunity to speak about the process when the item of the park branch came up, as you heard on the tape. I said at least twice, you can speak about that when the park branch comes up. So I'm not quite sure where the abridging of his speech came from, certainly not from me. My job as president of the commission is to interpret the order of the proceedings. We changed the language of the opening to describe what happens in opening comments to avert any confusion that seemed to be arising, even though it had been the same process for the last several years. Mr. Warfield spoke fully for his 3 minutes at the opening of the meeting. He spoke fully for his 3 minutes during the Park Branch discussion, and he spoke fully for 3 minutes on every agenda item in that meeting. Thank you.
Thank you. Mr. Warfield, do you wish to make any concluding or rebutting remarks?
Yes. First of all, you had the exact same issue here when Sue Coughlin had a complaint about what happened in June and brought it to your July meeting. She wanted to speak about the process by which North Beach planning had occurred and was not prepared to speak on that when there was a discussion of North Beach design. The supposedly loose interpretations that you're getting, I'm sorry, I don't agree. Your Ms. Craven, I'm afraid, is putting us in a very dangerous place where you have great freedom to ignore what the agenda item says on item 1, and then you could say on item 2, you know, we're going to have a strict interpretation. What the library did in the process has nothing to do with the peer review or what they said, or even anything to do with the design of the branch. On a library that's 100 years old, the oldest in the system, that has many issues with regard to the design, within or without the peer review, the process was a distinctly separate and very concerning issue that I had a right to speak on under the item as you read it. All this stuff about customs, just read the item. There's another issue, and that is the very speaker following me. The very speaker following me spoke precisely about the process by which planning for the library renovations have gone forward. I'll play you a brief beginning of what she said, and she was not stopped at all.
Good afternoon, Commissioners. My name is Tess Walborn, a resident of Haight-Ashbury. I would like to talk about planning processes and suggest that you might ask the library to use some different planning processes with planning of future branch renovations. For example, when
A resident of the Haight-Ashbury, she was a former president of HANK, which was the neighborhood group at which Ms. Gomez and I had been speaking on March 12th to present what was going on there on opposite sides, as it were, agreeing and disagreeing with the library's plans. This person spoke for 3 minutes, uninterrupted in any way, about planning processes. And that seems to be the key here, and that is, it was the content of what I was about to say that was objectionable to the president of the Library Commission, and not some interpretation of what was going on with respect to the agenda item. I followed what the agenda item said. I was entitled to speak on the topic that I was speaking. I even went beyond what was necessary and differentiated what I was going to say as distinct and apart and separate from and different from what the agenda item said, even though I didn't have to, but I did anyway, and it was a separate item. You had exactly the same thing in your July meeting when you voted in favor of Ms. Coffin's complaint on a 6-0 vote. Thank you very much.
Thank you. Task Force?
I have another comment. The library did change the description of general public comment so that it would be specific as to their intent. They said it should be about an item that's not elsewhere on the agenda. They have not yet changed their language regarding peer review. Every time they have a design for a new branch, they have peer review. So my suggestion would be, if they really mean peer review to encompass anything anybody wants to say about that particular library, they should say Park Library project, including response to peer review. That would make it specific. But Section 67.7 says that there should be a meaningful description on the agenda, should be sufficiently clear to alert someone that they should come to the meeting and testify on it. So I think since the library has changed their definition of public comment in response to the complaint that, the other complaint that we had here about public comment, I would simply suggest, if they want to be specific, if they want to be general when they talk about peer review, they should also provide on the agenda a notice that this will be about any subject involving that particular library. But they didn't do it on the May 19th agenda. They said response to peer review of Park Library. That's very, very narrow. So as I said before, under that specific rubric, if Mr. Warfield had tried to talk about the planning process or other aspects of the process, he could have been ruled out of order. So I think that there was definitely a violation here, and the fact that the library has in fact changed their agenda to conform indicates that they wish to be more clear about how their agenda writes things out.
Okay, is there a motion to find violation?
I move that we find the library in violation of section 67.15, failure to permit public comment.
Is there a second?
Second.
Moved and seconded, discussion. I have a comment. I tend to agree with Member Coffin on this. The process itself was not among the items listed in item 2 at that meeting, and Member Coffin points out, I believe correctly, that if Mr. Warfield had attempted to discuss process when the Park Branch item came up later on, he could have been moved out of order because the items to be discussed in that particular item were very specific, and what Mr. Warfield wanted to discuss was not among them. So I believe his rights were violated here, and I will vote to support the motion. Is there any further discussion? Member Craig and Green.
The only reason I'm not going to support that motion is because the item agenda I read is very broad. It actually deals with bond program manager's report, which deals with the report will consist of an informal presentation, regular reports, program budget schedule, construction reports, active projects, and community outreach. That's with all the activities happening under the bond measure. All improvements at every library. And then it says special reports. On this particular agenda, it was special report. So it's a subsection of what's included, including Park Branch peer review response. The other agenda that Ms. Coffin had, Thursday, June 18, 2009, had the same report will consist of informal presentation, not regular reports, program budget, schedule, construction reports, active projects, and community outreach, and special reports. At that one, it was peer review responses, Golden Gate Valley Branch, and Mayview. So all comments on all bond issues, to me, belong under item 2. That's, I guess, the reason why I would not support the motion, but I fully understand the other motion.
Member Kaufman?
I need to clarify what this item number 2 actually means when, where is it? Bond manager report. The bond manager gets up at once a month and talks about the entire branch improvement program. She talks about all 24 projects and what their status is. In this, I don't know why they included peer review response in this particular item. It's usually a standalone item, the bond manager's report. Usually they have peer review as a separate item and peer review response as a separate item, as it should be properly. So the bond manager's report is talking about all branches and actually their status. It's not talking about specifically planning and so forth. And the fact that they put the peer review response in here would indicate to me that when they're talking about Park Library, all they want to talk about is how the library is going to respond to the architect and librarian who did the peer review and made some changes in the design. So that's very narrow. Maybe they will change, I would suggest that they change the agenda, they would change the content of the agenda so that it encompasses, if they mean to encompass a very broad area here, they should say so. Otherwise, they're violating section 67.7 of the Sunshine Ordinance by not being clear enough.
Further comment? Seeing none, roll call, please. On the motion.
On the motion, Member Craven Green.
No.
Member Craven Green, no. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn is excused. Member Knepper.
No.
Member Knepper, no. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
No.
Member Goldman, no. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 5 ayes and 3 noes.
Motion fails.
Member Chi, could you explain to, I see how they're looking. Could you explain to some of them what that means, what we just did?
Well, yes, in order to pass a motion, a substantive matter, 6 votes are needed for passage because the task force comprises 11 members, and the majority of 11 is 6, and this did not get 6 aye votes, so the motion fails. There is no violation here, and no further action, no referral, no anything. The matter is closed. Thank you both for attending. Mr. Clerk, can you read the next item, please?
Item number 4 is the determination of jurisdiction filed by Peter Warfield against the public library for alleged unlawful and unjustified redaction of documents.
Okay.
Members, I move that we find jurisdiction on this item. Second.
Moved and seconded to define jurisdiction. Is there public comment on the matter of jurisdiction? Seeing none. Task force? No comment among task force. Roll call, please, on jurisdiction.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn excused. Member Knepper.
Aye.
Member Knepper, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Mr. Chair, we have 8 ayes.
Okay, we now move to the merits. Mr. Warfield, please approach. And you have 5 minutes.
Thank you. We requested information from the library about Park Branch Library's planned renovation that included correspondence, and received a copy of email with these problems. First, contact information for the sender, such as the email address of the sender, was blacked out, redacted. Second, there was no explanation of what the reason was, as is required by the Sunshine Ordinance. And the Sunshine Ordinance requires that each item be flagged with a footnote or an explanation directly on the item. So the violations there are 67.21A, process for gaining access to public records, 67.26, withholding kept to a minimum, and 67.27, justification of withholding. Again, I did not provide you in your packet with an example, but this is an example of a letter to City Librarian Luis Herrera, Chief of Branches Brian Bannon, and Mindy Linetsky. And you can see at the top, and this is a blow-up, that the sender's something has been blacked out, and from the circular thing in the sort of middle, it looks like it's probably the email address. Also, because the format, if you're familiar with it, has from and to with the email addresses, so you can figure out it's probably the email address. But as you can see from the letter, there is no explanation on the page as to what was taken out, why it was taken out, what justified the taking out, and so on and so forth. Furthermore, the library, in its response dated September the 16th, tells us that it routinely does this. as a matter of policy. When I read from the library's response on September the 16th, which I'm not sure what page on your agenda it's on.
Begins on packet page 33.
Thank you. On the first page of the response, under the heading at the lower portion of the page, redaction of home addresses and home phone numbers, the library writes, where the contact information for the sender is a home address and or home phone number, the library redacts such information. Period. Then it goes on in the next paragraph. It says the library does not release home phone numbers and home addresses of individuals in order to protect their right to privacy. And then it goes on with some citations. But it doesn't cite the Sunshine Ordinance itself as to where it's entitled to specifically withhold those or must withhold those pieces of information. On the next page, 34 of the packet, the second page of the library's September 16th response, there's a heading near the top third, redaction of personal email addresses. And the library writes, in general, personal email addresses are private and confidential. And then it goes on to talk about so on and so forth. So essentially, the library is saying that as a matter of policy, it simply withholds these pieces of information on a routine basis. And that is a very serious problem because it certainly affects many things with regard to people's right to associate, people's right to know whether something might be authentic or try and figure it out. And I would draw your attention to your own order of determination, which I hope I can find, with respect to a previous case that I brought before you in August. In August, there was an issue of the Board of Appeals redacting certain contact information from records that I had sought. And here you write in your order of determination, the task force noted it has consistently ruled that unless a member of the public requests anonymity is a whistleblower or someone who could otherwise face retribution if his or her name and contact information were known, the name and contact information for members of the public submitting public testimony is a matter of public record and should be released upon request. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, respondent. You have 5 minutes.
Thank you. Again, Sue Blackman. I'm the Library Commission Secretary and the custodian of records for the library. I would like to refer to our response that's sent on September 16th. And I actually would like to request that this complaint be dismissed because of the lack of information and the inability of us to respond to a specific complaint because there was no evidence of what record he is referring to. Mr. Warfield requests many, or has many requests for public information, and I do agree we do redact that personal email. I cannot address whether in one instance we may have, forgotten or did not respond, that we put an explanation in. We normally do that, but again, because I do not have evidence of what he's even complaining about, it's very difficult for us to respond to that. I will go on to say that we do stand by our letter of September 16th, and it is our policy to redact personal home addresses, emails, phone numbers.
Thank you. Is there anybody to present facts and evidence in support of the respondent?
Jewel Gomez, President of the Library Commission. We receive information forwarded to us as commissioners regularly that comes in from the general public. It comes in through the secretary's email and phone, as well as through regular mail, which is immediately forwarded to us. I believe this is the most efficient way to do it. If any of commission members or committee members were subject to receiving private emails or information on their private email from any members of the public who chose, I'm not sure how long you'd stay on your committees. As an example, last time when I came here and I asked the office of the commission if I could be early on the agenda, that message was forwarded to you, Mr. Nee, and you responded to me in a timely manner. I felt that that worked as a member of the public to get in touch with you. I was surprised when this complainant indicated I had called you at your home. There would be no reason or appropriate reason for me to call you at your home. That's why there is an office, and that usually works for most members of the public. Thank you.
Thank you. Is there anybody else to speak in support of the respondent? Seeing none, matters with the task force. Okay. Member Creighton.
I just want to preface my comments by saying it's a very difficult issue. It is one that we've faced a number of times, and I think we've been fairly consistent in how we've ruled, at least during my tenure. With respect to the first issue, which is Mr. Warfield's allegation that the library should be held responsible for failure to explain when information was redacted, and the library's position that should be dismissed because they don't have enough information to respond, I would agree with the library. There's no proof here about the request that was made and the response that was provided. All we have is Mr. Warfield's word, but there's no document showing what that violation was, so we really can't. In my view, there's no evidence of that violation. Maybe the library did mess up once, maybe they messed up 10 times, but we don't have that information. We do have their statement that they standard practice to respond. We just don't know if they did that in this case. With respect to the issue of redaction, that's really the much more difficult issue. And as I said, we have addressed this issue a number of times. I'll state what I believe our rulings have been. Anyone should feel free to, my memory is not perfect. My recollection is certainly imperfect. So people should be able to correct me if I'm wrong. And also, members of this task force may and should disagree with me if they find reason to. With respect to home addresses and phone numbers, you know, the United States Supreme Court and the California Supreme Court have really looked at the issue of privacy and internal privacy, and we discussed some of the cases that were cited in the library's memo with respect to Mr. Zarefsky's memo, which the library basically parrots and cuts and pastes somewhat inappropriately because they included a footnote that didn't apply to this case. But we discussed each of those cases in depth in the prior discussion, which was whether or not the emails of members, I believe, city commissions should be public. But with respect to home addresses and phone numbers, these courts have basically found that there is a zone of privacy around the home, and that, generally speaking, receiving mail, physical mail, is not the type of privacy invasion that causes a great level of concern. The Justice of the United States Supreme Court have found, you know, if someone is bothered by receiving an advertisement for contraceptives in the mail, there's an easy solution. You put it in the trash can. The United States Supreme Court and lower courts have also found that the phone is a little bit different. That when the phone rings, it cannot be ignored. That there's technological issues with having your phone line tied up if someone else can want to get to you. There's other issues about how that technology operates and how intrusive it is that subjects it, I would say, to more regulation and recognizes it's a greater intrusion of privacy. So based on that line of cases, in my general approach to this area is that home addresses, I believe, unless we have someone that's seeking government services as to which there might be a privacy interest, so welfare, clearly, Section 8 housing, those sorts of things. You have to go to the government to get those services. You have no choice, but you don't necessarily want all of your information to become public because you're seeking those services. In that situation, I think there's a good grounds for withholding home addresses. Also, if you're a whistleblower or if you fear retribution, so you're making complaints about your neighbor being noisy, and you really don't want your neighbor to know it was you. I think in that situation, you have good grounds for expecting and receiving confidentiality of your home address related to your transactions with the government. But as we found with the Board of Appeals, if you are commenting on public policy, you are submitting information to the library about whether or not you think your neighborhood branch should be torn down. I think it's important to know where that person is living. Does that person live in that neighborhood? Does that person live in San Mateo? Does that person live in Sacramento? Happens to be an architect and just likes modern architecture but doesn't utilize the resources. I think there is actually a benefit to providing home addresses for members of the public who are commenting on policy. It certainly weighs on the members of the commission who get to see the full unredacted version, right? Oh, this person lives in my neighborhood, or, this person lives in my district. They get to see it. Why can't members of the public? So I think that's a fundamentally, different distinction. So I believe that home addresses, unless they fall into one of those categories I mentioned, should be released. With respect to phone numbers, because of the sort of intrusive nature of your phone ringing and the concerns that the government, that other courts have held, I don't actually see strength for the argument that should be produced. And I think we haven't ordered home phone numbers to have been produced in the past when the issues are broken down with specificity. The more complex issue beyond that is the issue of email. And with email, I tend to see email as analogous to snail mail, to be honest. It is the modern way that people are communicating with their legislators. It is the modern way that people are communicating with each other. The majority of the cases that were cited in Mr. Zarefsky's memo, I think, are inopposite because they deal primarily with private litigants in the courts. The FOIA cases are arguably on point, including the Stott Nelson versus United States, which is a FOIA case. I think that our city attorney pointed out was perhaps the most relevant. Those cases are, I believe, more or closer to being on point. However, I disagree with Mr. Zarefsky in that I think the federal courts have interpreted privacy far more expansively than the California courts, especially considering the most recent issue in government records and privacy, the IFPTE case, which my partner litigated dealing with public employee salary. I think the California courts have taken a much more narrow approach to informational privacy than the federal courts under FOIA, if you look at the FOIA versus the PRA cases. So I don't think we immediately looked at FOIA exemptions, which are more expansive. I think the only court in California to have addressed this is unfortunately the unpublished case, the Holman case versus Reader, which they found that in that case, balancing the issues, the newspaper could get access to the names and email addresses, and also in that case, home phone numbers of reflected in the records of legislative aids communication, because the allegation was that legislative aid was being paid by a contractor or formerly worked for a contractor. So that's really the only case that is unpublished, so it's not really precedental. But I think weighing all the issues, our former opinions have been email addresses should be produced, unless, again, they fall into the category of information of someone seeking sensitive services from the government and they have no choice, or that they're a whistleblower or afraid of retaliation or retribution for their comments. So my opinion on this case is that the library should be found in violation for failure to produce home addresses and email addresses, but not home phone numbers.
Member Kaufman.
I just wanted to add to what Member Craven Green said, that this has been something that's been bugging me ever since I've been on this task force, and that's been a long time. And I have asked during the Rente for case law, we've looked at a lot of case law here, and it's all over the place. You know, I think in many cases it depends on the jurisdiction, it depends on the particular issue. There was one in San Diego, I believe, that ruled in favor of providing the information. I think there are press challenges that in many cases are complied with. The problem is, I think, I can understand what Member Craven says about telephone, although I find it very possible to let my machine deal with the telephone. Addresses are a little more problematical because people can come to your house. Email addresses, to my mind, you're completely protected. You can just delete it, or if you don't like it, you can just delete it. But no one knows where you live when they have your email address. So again, I could easily agree with Member Craven Green. I don't know what Mr. Threed has any opinions on this, but I would sure love to get another look at some case law, because as I said, it's all over the place. My opinion is that emails are, one of the reasons people write to the government is that they want to exercise their First Amendment right to ask for redress of grievances, but also they would like to be in touch with other people who are like-minded. And if you get someone's email address, you can write them an email. They don't want to have anything to do with you. They don't have to. So, in this case, and we've got a lot of redaction of email cases today. We've got several. But my personal preference would be that when emails are involved, they should be released to the requester.
Member Never and then Member Williams.
I do agree that I do think that emails should be released, but my problem with this particular case is I don't have the evidence in front of me. It's hard for me to say to find a violation. I don't see it in the evidence. I understand that they have admitted that that's their policy, but if I don't have something from Mr. Warfield saying this is the case, this is the actual piece of evidence where this is happening, it's hard for me to vote on that.
Member Williams.
Mr. Chairman, I just find out from dealing with the library for so long, and especially since seeing the CD that we saw and hearing what we heard, I really have a problem with it. And I think, Member Cochran, although that you are attorney and we welcome your wisdom, sometimes you talk over the public's head and you don't make it clear enough to what it is. And I see on page 33 that the library where it says Warfield submits regularly to numerous public records requests to the library, and in turn he received numerous responses to his requests from the library. Therefore, we have no way of addressing Warfield's allegations within his specificity. I don't care how many times Mr. Warfield asked the public, city of agencies, he has the right to that information. And again, going back on the other, I don't care how many times he got up there and spoke. If it was not on there, he had the right. And somehow, I'm feeling like the freedom of information is not being given to me, and we're not weighing the facts and the evidence toward the citizens of San Francisco, and I'm beginning to feel that way. And I think we should take a stronger look to the task force, not throw so much law at them, but what Sunshine was really written to be all about. Open government. They have the right to know what's going on. They have the right to know, and that's the bottom line.
Thank you. I wish to make one comment, and that is, besides the question of who has the right to privacy and who has the right to the records, if the library or any other agency feels that privacy is something to be protected, those agencies can affirmatively ask somebody who sends in an email or who writes a letter or who calls in if they want their personal information withheld. I don't sense that the library has done this. What I sense is that the library has a default policy of withholding personal information. And that default policy, to my way of thinking, is incorrect. At this time, is there public comment on this issue?
Member, can I just say, oh.
Ray Hartz, and I have to agree pretty much with a lot of the comments that have been made so far. I, as a citizen, if I want to get involved in government, have the right to ask them to withhold certain information, and that is my responsibility. If I send them an email, my email address is not blocked out, or my name is not there, or whatever, then it's obviously not possible for them to give out information I don't want to. But if I provide you with information, I do it for multiple reasons. One, if someone to whom I'm sending the message wants to get in contact with me, they can do so. But I also do it in the sense that if someone else has a comment about what I've said, that if they disagree with what I say or agree with what I say, I would like them to be able to engage in a conversation with me. And if they can't get in touch with me, then they can't do that. And for them to simply take my right away to communicate with other people is unconstitutional. And to simply say this is a public matter, it's open to public discussion, and we have two members of the public who, for whatever reason, would like to get in touch with either, but we're going to set up a roadblock where they can't do it, is really outrageous. You know, hey, the road to hell is paved with good intentions, and I really do believe they probably think that they're doing something for the benefit of somebody. But to sit there and say, well, we don't have a specific example. He came up and said they didn't give you this information. They came up and said, yeah, we withhold the information. They admitted that they don't do what's supposed to be done. Bottom line is they broke this ordinance. They didn't give the information they were asked for, and they didn't give a valid reason for not giving it. And even if they have one, which is point to the regulation is not valid. I have the right as a citizen to withhold my information. They don't have the right to withhold it on my behalf. They have no standing to do that.
Thank you. Is there further public comment? Seeing none, at this time, the respondent and then the complainant will each get 3 minutes to present any concluding or rebutting remarks. Ms. Blackman?
Thank you. I just want to clarify our policy. If there are emails or letters sent to the commission and it is part of the public record, I do not redact those personal emails or personal addresses, because I feel that because they are addressing the commission, they expect that their name, will be part of the record. If it's an email that's to a staff member, to the city librarian, I don't feel that those people have any reason to think that they do believe that they have privacy. It's not like they're addressing a public body. So not knowing, again, what the specific email that he's referring to, I have no idea of knowing what was redacted. I don't know if it was, it could possibly be a personal commissioner email, home email address. I don't know what he's referring to. So it's very hard to, again, take a position or defend what this issue is.
Thank you. Mr. Warfield?
Thank you. Again, I think that the Sunshine Ordinance should be followed, as well as the Public Records Act. And there is no reference, except in very specific circumstances, that you are entitled to redact so-called contact information. There are some specific references to employee resume materials that can have some of that information redacted, and that's about it for what I have found. If you were to do the research, I think you would find there simply is not a redaction permission in the law. There are redaction permissions with regard to ongoing police investigations and people in very sensitive positions, or with respect to sensitive medical information, but not contact information. It just ain't there. And with respect to the examples, as I said, I have 11 copies, if you like, of this email, which was from Tess Wellborn to the city librarian. It had to do with Park Branch and the position of the Haight-Ashbury Neighborhood Council with regard to the closure. But this is not unusual. You don't need to pretend that there's not something here. The library's own response says it all. It says unconditionally and without any conditions at all, where the contact information for the sender is a home address and or home phone number, the library redacts such information, period. It says on business or organizational, it does not redact such information. Then it goes on emails, it says unconditionally. Quote, in general, personal email addresses are private and confidential, period. That's what they do. And you haven't heard them deny it. They say they always provide this information. I've never seen it. I would like the library to show me several examples of stuff they have given to me or anybody else that shows just what their technique is for identifying what's been redacted and saying why on the specific item, such as I've shown you here, and would be glad to provide you copies. They just don't have it. They haven't shown it to you because they don't do it, certainly not in my experience. Now, there's a lot of, it seems to be, real paranoia going on with regard to contact information. If you look at a phone book, people's addresses, names, and phone numbers are in there by the thousand. I used to wonder, why don't I get calls in the middle of the night? I don't. All kinds of addresses. I was looking at the 1909 city annual report. The library commissioners have their business and home addresses listed. If I come to this meeting and somebody hears something I say, they can come up to me and say, oh, I'm so glad you said what you said. Can we talk about it? I agree or I disagree with you. I can say I don't want to or I do want to. And the same with phone numbers, with emails, and with home addresses. Most people get it when they're asked, please don't bother me, I'm not interested. And there are laws that protect people from being hassled or harassed if the person doesn't get the hint in a normal way. Thank you.
Thank you, Mr. Warfield. The matter is back with the task force. Member Chu?
I agree with my colleague here that we don't actually have any proof that this happened, even though I believe it probably does. And we've been getting these documents that are showing up during our meeting, while we're having discussions, and that shouldn't happen. I mean, I understand he's got a document, but we need to see this stuff ahead of time. It's like the crux of the case. So I would be reluctant to vote on any kind of violation here. Having said that, it does sound like there's a stated policy, and that our Education and Outreach Committee could have a conversation with the Library Commission about that policy, which I think we probably don't agree with, and help them understand some of the law around it. So that's what I have to say.
No, I might suggest that, Mr. Warfield, could you just come up for a second? What was do you have the documents that you, do you have your request and the response, the redacted response? Could you provide that to us if we continued this?
I might be able to find the request. I'm not sure if I can find the request. I certainly can give you the document either today or any other time that you like, which was my example of this. And if you were to continue it, I would certainly be able, I think, to find other examples as well.
Because you do say in your papers that it had to do with the Park Library renovation, but if you could give us something specific that we could see that you requested, and then that there was a response in which there were redactions, maybe we would have a little more specificity as to evaluate your claim. So I would suggest we consider continuing this and give Mr. Warfield an opportunity to come back with a specific request that he made and that was redacted, and that the response was redacted in.
I second the motion.
There's a motion to continue. Is there public discussion on the motion to continue?
Yes, Ray Hartz, and I see no real reason to continue this. Mr. Warfield asked for a public document, they didn't give it to him. Bottom line. Okay, they redacted something they shouldn't have redacted. I mean, that's not in question. And really, unfortunately, what this has become is a very, 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 very long, complicated application for a public document. That's what this has turned into. Mr. Warfield wants something as a public document, they won't give it to him, and instead of him coming in here and getting the instruction where the person is told, if you can't give a justification for not giving it to him, give it to him. And if it's something that you redacted, and we've indicated in every other thing we've done that we don't allow that redaction, to simply say, well, because they've got a specific example, we can't actually do anything. The bottom line is, they're public records. If Mr. Warfield wants to look at them, he should be able to look at them. If he wants to contact people through the emails or whatever that they provided of their own free will, he should be able to do so, and they're thwarting that. And this turns into a big, long, complicated thing about, okay, give us this or give us that and whatever. And it doesn't really matter because I presented stuff to the thing, and I've had people, like last meeting, 5 of you came in, and 3 of you were handed the packet when you walked in the door. You didn't have any time to review it. And I actually had one person say in one of the hearings I was involved in, I don't need to see the documents. Oh, what does that indicate? I don't need to see your side of the case. They are holding something back that they shouldn't hold back, find them in violation, tell them they need to clean up their act, and quit being so damned nice.
Further public comment on the motion to continue. Ma'am, you're a party in interest.
I can't oppose the continuance.
No, you may not. You may not oppose it, you may not support it. You're a party in interest. Further public comment. Seeing none. Task Force Member Knebber.
I'm inclined to oppose the continuance because, again, I mean, if he has kids, I just don't like the idea of keeping this going. If he has specific instances and he wants to file another complaint, I'm happy to do that. But continue it over, I think it's unfair to complain and to just keep going and keep going. I mean, to the respondent. Just my 2 cents.
Okay. Further discussion? Roll call on the motion to continue, please.
On the motion to continue, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn excused. Member Knebber.
No.
Member Knebber, no. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
No.
Member Goldman, no. Member Williams.
Aye.
Member Williams, aye. Member Chu.
No.
Member Chu, no. Member Need.
No.
Member Need, no. Mr. Chair, we have 4 ayes and 4 noes.
Motion to continue fails. And we're back with the main item now. Does anyone wish to present a motion to find violation? Seeing none, the matter is concluded. We wish to thank both sides for attending.
Could I just make a request of poor Mr. 3, who's so new, but we have Ernie Lorente had a great file on redaction cases. Could you pull something up, maybe bring it to our next meeting? I'm just really interested to see what the state of the art is on that subject. Because it's such a massive one, and it comes before us all the time.
I'd certainly be happy to talk to Mr. Lorente when he comes back from vacation and see what he has and take a look at it and respond to your questions.
Okay.
And then, Mr. Tree, I would like to know, when we don't have enough members, that was my reason for continuance. You can always tell the way it's going from the votes that it's going, So that was my idea of continuance. When we don't have that 6, we just drive the hours.
The Chair would further suggest that although we have found a violation here, the Education, Outreach, and Training Committee might want to take this issue up with the Library Department and the Library Commission, because it is apparent that they have some standing policies that may flout statutory and case law.
Thank you. Fine with us.
At this time, we're going to take public comment on items not appearing on today's agenda. This is the time for general public comment.
Hearts, and I would like to say happy anniversary to me. This is my second year in dealing with the city government in various aspects, different commissions, the police department, this task force, and so forth. And I guess along the line, probably a lot of you have wondered, what exactly is this guy up to? I believe in open government. Served in the military for 12 years because I believe that you have to put up or shut up. I defended my country, and one of the things that I'm entitled to do that is freedom of speech. And I intend to use that by attending every single commission meeting I have the possibility to do. Commissions, boards, supervisors meetings. In fact, I spoke at the supervisors meeting today, and I talked to them, kind of upbraided them maybe on their remarks, because about 6 months ago there was a supervisors meeting, and one of the gentlemen got up and he started making some intemperate comments about prostitutes or whatever, and one of the board members of the Board of Supervisors got up and got in his face. Made him shut up. Well, the bottom line is, I think that's the real problem with our civil discourse these days, is that some people think that their right to freedom of speech includes the right to drown out other people's voices, and that is not what it is. If the supervisor has a problem with something a person says, then they have the right to respond to that, but not to interrupt the person when they're speaking. They also had another gentleman who was upset because he looked at the Board of Supervisors, which you can often do, and you can tell that not one of them is paying attention to you. And he got upset and actually got it in the word, "Shh, no, you can't say that, you can't say that." Hey, I don't care what anybody says. If you ask most Americans what they think is fair, what they're going to say is, when you go to the government and you petition them for a redress of grievances under the First Amendment of the Constitution, they have an obligation to at least listen. Not to ignore you, not to evade you, not to run away. And that's one thing I've seen in city government in the last 2 years. Every single board or commission I have come in contact with does their honest best to never have a conversation with an individual. They will come in here and fight over and go back and forth and round and round, but nobody in the management of those departments will actually call up the person and say, "Look, this is silly. We are wasting energy, time, resources. Let's sit down and figure out what it is you want, and let's try to get it to you so that we can all go about our business." And that's the thing I, as a citizen, object to. That we spend endless hours. Like I told you earlier, what you have become is a long-form application for public documents. I have to fight you, and I have a lawyer against me, and I have another lawyer against me. Because we all know the city attorney's office is just adamantly opposed to open government. And I intend to bring this to the attention of every single city agency. I'm going to go to every commission, and I'm going to use some of your own cases where their departments go. And I'm going to say, what is it where the executive of a city department signs a document saying he understands sunshine, will implement sunshine, and then comes in and sends people who say, we won't follow sunshine.
Thank you.
Wrong.
Thank you.
Good evening. My name is Randall Evans, and I'm here today to try to get folks to understand something real clear. At some point today, you're going to see some folks come up here and discuss some issues that have to do with a particular part of the community, deal with particularly people that look like me, black folks. The unfortunate part is that what you don't know is that you can look at San Francisco and see 5 black people stand together, and you wouldn't even know that they don't speak the same English or the same language. But then you'll turn around, maybe to the mayor's office, and you think you're talking to someone that represents me. And at the end of the day, my children's children or no one that knows me is involved. We have a president today that deals with something that you all are supposed to be concerned with, and it's called transparency. It's unfortunate that I have to be here to file a complaint about something at the end of the day won't amount to a hill of beans, won't get me where I want or where I'm trying to go. But you have this particular vehicle here in front of me, so I'm supposed to use it. Now watch this. In my community, these 5 people that you don't know that look like me, there's all kinds of things that are happening that they wouldn't even think of coming down here, won't be here, cannot understand that. In their eyes, this is a foreign language. So now you find it hard to understand me, right? But what I'm saying is that it's difficult to believe that we have a black president today that says that he believes in transparency. So we hold you responsible to help us understand how to gather information without having the kind of chaos that makes us go to jail, and help us see through it. Sometimes at the end of the day, you'll say, well, it's not important It's not viable, it's a non-profit organization, it's passive, it don't mean nothing. But we're here because this is the only route we got, so we call you the police, right? Y'all the police, and you're supposed to get involved in something, help us understand how we get through. So what I'm trying to tell you folks today, I don't know how you got there. I heard you saying you've been there for a while. I know you know, and I'm stressed out. I'm working night and day trying to stop an eviction. Got family out the penitentiary and family in problems. Got good things, my daughter's in college, but I don't have no say-so, no input, no idea where I'm going and what's happening for my future or my children's children in the place where I was born and raised. So here I am today, going to be in front of you guys dealing with situations that you might pass, you might not, but I'm not here to get your approval for me to get information. I'm here to hope to raise your awareness that if you guys are sitting here and supposed to be responsible for helping us understand how to get through the Information Act, then you need to tighten your act up. Because at the end of the day, if we find that folks are not only not cooperating, but they're deliberately making it difficult for us, then I think you guys should think about taking a step further and help us understand how to help these people get off of these committees and stop acting like they're supposed to represent these fine people who they don't even communicate with.
Thank you, sir. Without meaning to make light of your remarks, I should point out that in Britain, they think that nobody in America speaks English.
I'm not British.
Good evening, Commissioners. My name is Ace Washington. This is about the second time that I've been to your meetings, and then last time I came it was similar to what we're going to go through today. And I feel the same way as the last speaker, because when we came last time, nothing was done. There was words that was used that their attorneys told to use passive groups and all that kind of stuff. But I want to warn y'all to let you know that there is a new day here in the city of San Francisco, as well as all over the country, transparency. So that is what us community activists that's been wanting for a number of years, that has been stopped by people that look like us. So the time is out for those that have been favoritism. After this meeting that comes up, I'm going to show as a material witness and show a parallel that in our community, there is just very few people that has control over monies, over programs, and everything else. But they'll be able to run rapid in our community like there's no accountability. And the reason why is that? Because the political muscle that's been allowed. The Willie Browns, you got Gavin Newsom. So you got two sets of Negroes, and I hate to say it like this, that's fighting amongst each other. And then we're going to have, if we got to come out here to wash our dirty laundry, that's the way it's going to have to be. Because it's going to be transparent, and as the status quo that has been going on for a number of years has to stop in order for our children's to be able to. Because right now, let me tell you something. I'm the only reporter that was in some very important meetings for the history of our African American, what is called the Mayor's African American Out-Migration Task Force. But right now, that report was supposed to be 2 years ago, but why it hasn't? Because people like me are in there fighting and fussing over situations that we are dying for a report to come out to be funded. But the reason why it hasn't is because certain people are holding back because there's no funding behind that would take place. And that comes from transparency. So I'm not here to point fingers at nobody. I'm here to tell the city and county and all my African American people, time is redemption. I'm not trying to point the finger at nobody. Let's go forward. But those that want to resist and say, and my statement is to them, and in this room here, we cannot continue to do what we've done. Because if we do, we're going to get what we got. And absolutely what we got is nothing.
Thank you. Is there further general public comment?
Good afternoon. My name is Robert Garcia. I'm president of Save Our Streets Tenants and Merchants Association. We have 75% of the clubs in San Francisco in our neighborhood. And we have 4 more slated for a 10-block area. One wants 4,000 occupancy load, another one wants 1,000 occupancy load, another 800, and another 600. That does not include turnover, which would probably be 3 times that amount. And the Entertainment Commission is withholding information from us. They're not posting properly. They are breaking every rule. When there is a continuance, they're supposed to repost for 10 days. What they do is wait until 5 days before the hearing, and they post. And because they have their own rule which says that you cannot protest within 5 days of the hearing. So they cut the protesting time in half. I'm sorry I don't have enough photographs and information for everybody because I left a lot of it at the last hearing. But I do have photographs that will clearly show that this was posted on the 7th, and the deadline for protesting is the 12th. There you can see that it was posted 8/7, and the deadline for protesting is on the 12th. That's 5 days. Even the captain of the police station protested that it hadn't been posted properly and not in a conspicuous place. There you can see that it's a little difficult, but that's 4 feet inside. That's a 4-foot setback from the property line. That is not a conspicuous place. And they posted on the other side of the building exactly the same way. And it says very clearly that it needs to be posted in a conspicuous place. So we're having problems, and also the files are not available to us. We go in to try to look at the files, and they say the files are not there. Why aren't they there? These are public documents. They're being amended. Well, give them a copy. I had to purchase it, $5. They didn't give me the originals. They kept them in the files. There it is. But yet, on the day that we received that, they were amending it. And we could not get it. We tried to get it for 3 days and finally got it a half hour before they were closing their offices on the last day of the protest. Now, this will be coming before you, and I'm just here to let you know that this is absolutely out of control. We need to have...
Okay, sir, you could conclude your remarks, please.
Yes. This needs to be transparent. We need to have documents in the files, and they cannot be hiding them from us. There was a massive protest against this. They're saying that there's only 3 protests, and that's absolutely bogus.
Thank you, sir. Is there further public comment on non-agenda items?
Yes.
I'm Phil Rioli, Citizens United for Neighborhood Planning. I'm also involved in protesting the huge nightclub developments in Lower Nob Hill. I have had extreme difficulty getting information from the Entertainment Commission. And at this point, based on my research, what we have at the Entertainment Commission is long-term systematic breakdown of sunshine processes. It began to be documented by the civil grand jury of 2006-2007. They couldn't get even basic information about who the Entertainment Commission Executive Director reports to. They requested reports that the Entertainment Commission is supposed to issue annually by law, and they concluded that these reports were manufactured at the last minute based on their request. The one report that was issued contains no substantive data whatsoever and has, in parts, missing information about the number of permits. In the case of my documents, I actually had to request hard copy of permit documents because there is no place in the city that anyone knows how many permits the Entertainment Commission is issuing. It's really relevant to the pending legislation because the supporters, including the Entertainment Commission, are reporting that the early morning entertainment permits that are currently issued yearly are about 15, maybe 12. The legislation is about making entertainment mandatory from 2 a.m. to 6 a.m. in our densely residential district. The Entertainment Commission is hiding the number of permits it's currently issuing. They are because I requested the documents and finally got them after 6 weeks. They are about 80 a year. It has tremendous impact on the neighborhood. It's clearly intentional on the part of the Entertainment Commission to prevent us from having information that we need in order to discuss openly legislation that's going to dramatically change life in San Francisco neighborhoods. I have a letter that I forwarded to Frank Darby of my letter of June 5th. It's a complaint to Kamala Harris and Dennis Herrera that explains in full detail the problem of withholding of information by the Entertainment Commission. Only 19 of 38 Entertainment Commission meeting minutes are posted publicly on their website. The ones that are missing have, the agendas show they have to do with the formation of the legislation which the Entertainment Commission created. I've already brought up the point that none of the reports, the reports, all committee and commission reports are posted on the library website. No reports have ever been posted by the Entertainment Commission in the 5 years it's been operating. When I finally did get the documents, I now know because I've gone through every page, every 2,000 pages, every one of 2,000 pages. I know the trends in permitting. It's about 80 to 100 a year for the early morning entertainment permits, the ones that go after 2 a.m. 2007, there's a huge void there. I only got permits for the first 6 months. When I couldn't track permits that I knew about, I requested the balance of permits for 2007. I only got the permit copies for the exact documents I knew about.
Could you wrap up your remarks, please?
My remarks can be summed up by saying that clearly for 2007, the Entertainment Commission is continuing to withhold the permits, and it's extremely relevant to the current legislation that could be moved forward.
Thank you, sir. Is there further public comment on items not on today's agenda?
Yes, Peter Warfield. Last month, this body found the library in violation of sunshine on an 8-0 vote, and the Board of Appeals in violation of sunshine on an 8-0 vote. Under the law, they would have 5 days, I believe, from the time they were notified in writing to produce the documents that you ordered them to do. We are now on the next month following your finding of a violation, and these matters are not on this agenda, even though they have not complied with the order of determination. They were, to one degree or another, openly defiant in the Compliance and Amendments Committee, which I attended. The Compliance and Amendments Committee read letters from the Board of Appeals which said that they had made a partial mistake with regard to what material they had redacted from my requested letters. But they said that what you said they should provide, sorry, we ain't gonna do it. That was unfortunately not enough for the Compliance and Amendments Committee to determine that this matter should be on the agenda for tonight's meeting. The library said that the document they had responded to me on, the 50% construction documents back in March, when I asked not for 50% CD but for plans for Park Branch, they said, okay, you ordered us to give him 50% CD, fine. We'll give him that document, which was prepared actually in January. But they openly said that if we get a request from Mr. Warfield on something more recent, it might be a different story. That was a hint to the Compliance and Amendments Committee that it did not take up. So I think that Mr. Hartz has a good point when he says that it's an interesting concept. You have become a long-form application for public documents. And long form is also long time. Now the chair, in discussion, said that he was willing to put one of those items, the library, on this agenda in case they hadn't complied, and then this body could take action as required by law to forward the issue to another, if one might say, higher power. I was promised that that item would be on the agenda. It is not. Now, in between, there have been all kinds of administrative delays with this letter and that letter and that letter and the other letter, and this was late and that was late and that was late and that was late. The bottom line is, there's nothing on tonight's agenda, and this stuff will drag and drag and drag 2 months after you found a violation for you to send it to where it should have been sent within a very restricted time under the law, and that's very disappointing. Thank you.
Thank you. Is there further public comment? General public comment? Seeing none, general public comment is closed. Mr. Clerk, could you read item 15, please?
Item 15 is the determination of jurisdiction filed by Randall Evans against the African American Art and Culture Complex for allegedly not providing documents under Chapter 12L.
And once again, members, I move that we find jurisdiction on the side.
Second.
Moved and seconded to find jurisdiction. Is there public comment on the jurisdictional aspect only? Seeing none, public comment is closed. Is there comment on the motion? Roll call, please.
Do we have any response about the jurisdiction?
We have not received.
Nobody is contesting jurisdiction.
There is an issue here, though, on the.
Well, you're talking about the respondent's time?
No, Mr. Chair, there is a restriction order involved in this issue that we discussed.
Refresh my memory, please.
I had informed you that there was a restriction order issued against the respondent and that the city attorney was looking at it.
You're talking about a restraint order.
Yes, restraining order, sorry. And I have not heard back from the city attorney.
Okay, the restraining order was issued against the complainant?
Against the complainant, yes.
Okay, and that restraining order says what?
Ask the question.
May I speak?
Please approach.
The person who actually is on it to speak.
Please, excuse me, sir. Could you approach, please?
Certainly. I apologize if I'm not familiar with the procedures here, so perhaps I'm here to speak. I'm not quite sure if I'm to speak on 15 or 16.
Right now, we're on 15.
And can you explain to me what that means?
Well, the 15 is simply to discuss whether your complaint, whether the complainant's complaint falls under the jurisdiction of the ordinance and the task force. That's
Okay,
all
so
there
that has
is.
nothing to do with me.
That has nothing to do with the actual merits.
Right.
So are you contesting jurisdiction?
No, I'm not.
Okay.
I do have documentation, however, that Mr. Ruscombe was referring to, which is a
Restraining order against the complainant, and what is the nature of that restraining order, please?
As I understand, and I was asked to present this on behalf of the city attorney's office, there is a restraining order between the complainant and the executive director of the nonprofit organization African American Art and Culture Complex. And that restraining order includes the request of documentation, including, I have a copy of it, including correspondence in any means, including the use of public or private emails, inter-office mail, fax, etc. So there has been some complication regarding being able to provide the requested information because of the restraining order.
That, I think that goes to the merits of the jurisdiction, so we should just take up jurisdiction and move on to the
We're
merits.
taking jurisdiction on.
Okay, I'm sorry. I want to say I'm unclear which section I
Right
need
now,
to speak to.
okay, you are not contesting jurisdiction.
No, I'm not contesting.
Please be seated.
Okay, I beg your pardon. Chairman,
Member Chu.
it looks like there is a question of jurisdiction. Mr. Street, I mean, are you suggesting that we do have jurisdiction or we don't? Because your structural amendment doesn't say one way or the other.
Yeah, as far as I understand, there's been no objection to jurisdiction.
So you're saying we do have jurisdiction?
Well, I haven't laid out whether you have jurisdiction or not. This is my first meeting. I've conferred with those who've done it before. My understanding is that when there's no objection, we don't do the jurisdictional letter, our office. So that's not an issue I have addressed in analyzing the item on the agenda.
Member Craven, do you believe you have jurisdiction?
There's an issue of whether or not 12L applies to a certain complaint, whether or not the prerequisites for compliance with 12L is satisfied. There are those issues. And we have in the past taken up issue of jurisdiction where we have enough information to describe whether or not 12L is satisfied. Here, we don't have that information, so I would assume, as long as there's no contest here, I would assume we have jurisdiction, we can deal with that issue in the merits. Right? You know, is this appropriate in terms of timing, have all the things been exhausted? So, if I don't have any information based on the materials in our packets to be able to decide that now, we're going to have to ask questions about it.
Why don't we ask those questions now? Because,
I mean, to me, yes. I mean, to me, this is a finding of do we have jurisdiction to hear the issue, right? So, if we don't have jurisdiction to hear the issue, my instinct is that it's not a problem to say we have jurisdiction to hear it. If there are issues that we find that say, this is out of our, we don't have to have a determination. We can just say there's no findings on the merits. So I don't think it's a problem with our procedure or due process to vote on jurisdiction and go forward and hear the matter.
okay, but during hearing the matter, you're planning on asking questions on whether they meet that threshold, the 12L threshold.
Whether 12L applies, or whether there's other provisions that would obviate need to comply with 12L, yes.
I just have concerns that we could spend an hour on an issue that we find that we don't have jurisdiction in. So.
Member Nee, if we didn't have jurisdiction and we went to the complaints, compliance, why did you put it on the agenda? And everybody came out here and we've been out here this long. This doesn't make good sense. We're here.
Question of jurisdiction is being debated right now, and that does go properly.
I want to vote for jurisdiction.
Can I ask a question?
Member Coffin.
Why would we not have jurisdiction? Is this a group of passive meeting body? What is it?
Well, I believe it's a nonprofit that does work for the city.
Don't we have jurisdiction over nonprofits?
To a degree, yes, that goes under 12L.
It's over $250,000.
It's just been, in the past, if we found there hasn't been compliance with the prerequisites of 12L and 12L applies, then we have found there's not jurisdiction. All right, so it is a jurisdictional issue to some extent. I don't have enough information right now to answer that question, so I'm suggesting that we vote. I will defer to the chair.
On the question, is there further is there further comment from the task force on the matter of jurisdiction? Okay, roll call please on jurisdiction.
On jurisdiction, Member Craven,
Aye.
Member Craven, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn, excused. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson. Member Johnson, excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Lee.
Aye.
Member Lee, aye. Mr. Chair, we have 8 ayes.
Okay, we move down to the merits.
On the merits, can the complainant please approach? You have 5 minutes to state your case.
Before I start, I need to ask you a question. You guys allow information in without my attorney being here, and you listen to something that has to do with that. So do we talk about that? I was out to pitching.
about this. There is no restraining order, first of all.
You can address what you need to address in the merits, sir. You have 5 minutes.
So what do you want me to do?
Address whatever you need to address. You can address the issue of the restraining order. You can address the issue of the complaint. Please address all of the issues.
Okay, let me know when the 5 minutes start.
5 minutes will be starting now.
All right. So my name is Randall Evans, and it's simple. It's plain. First of all, it's just plain transparency in information. I've went to all these organizations, and I've said to most of them that we're going to be sun-shining information to have a community meeting to talk about transparency, to figure out how we don't duplicate and undermine each other. Unfortunately, where we are at, and I'm not just talking about one particular area, there's one mayor's office, there's one police department, there's one San Francisco General Hospital. We as black people must understand there's only one black community. In order to do that, you have to talk about where we fit in at and who's doing what at the end of the day. Now you guys are here trying to figure out whether or not you have jurisdiction on us, just finding out how we function in our communities so we can hold people accountable, especially ones that become commissioners that still live in the community, that put people in jail and throw out restraining orders and accuse people of things, put them on bail, and all we're out here doing is trying to get information. I've never put one foot of mine in a penitentiary. I've been in trouble many years ago. I'm 52 years old, born and raised right there in San Francisco in the Gilmore area. Now I'm at a point in my life where I'm trying to deal with my children's children. I have a daughter on her way to college, and she's going to come back. They're going to call her Rochelle Dr. Evans. But right now, I'm having the hardest time in the world trying to figure out how do you get black folks to understand with a black president that we have to change our spirit and start pulling together how to come together to help each other. I don't get that same response from commissioners. Now, I'm not ashamed to say it, and when I get to my community, I got to live up to it. There is no black leadership in San Francisco. That's it. Because there is no black leadership. There is none. There's nobody in San Francisco black leading us in a sense so we can come together other than come to you so we can talk about our issues, resolve them, and move forward.
Mr. President,
now, you asked me, I asked you what I could speak on, so you got I got 5 minutes.
Sir, let me caution you.
What's the caution?
So let me caution you that your remarks should be restricted to the matter at hand. You have a specific
It's
complaint.
simple. You I know, you got the complaint. You have it, though.
That's right, but you're not speaking on the complaint.
What is there to speak on? It's plain English. I asked for information. I got no response back whatsoever.
Fine.
Not even a letter.
Then you should address
I have addressed that. Whether or not you're going to make whatever adjustments you call to make, I'm going to still be Randall and live okay when I walk away from here. But right now, I want you to understand it's deeper than that. Now, it doesn't take a rocket scientist for you all to figure out that she's not even here today. No one from that particular organization has sent you one letter. I have nothing information-wise. Am I angry and upset? I'm a little disappointed. Now you're asking me to explain for 5 minutes what happened. I went through the process that you told me to go to. I sent the letter. You have copies of everything I've done. And I didn't get it. And you want me to speak 5 minutes on that? Let's go. I'm trying to explain to you how bigger the picture is. I'm trying to get you to understand how it might be boring you, but it is what it is. You get it?
Sir, the 5 minutes is a maximum. You don't have to take it.
Excuse me?
The 5 minutes is a maximum. You don't have to take it.
But I never said I didn't want to talk. You're just trying to tell me how to talk.
Well, sir, I'm trying to get you to focus your remarks to the complaint.
I don't know how far to go. I appreciate you guys saying you have jurisdiction. I'm looking forward to getting the information so we in the community can do something about understanding it. Now, if I'm going to lose your support by not being more specific, the lady's trying to put restraint on me. I'm trying to speak as small as about her as possible so I don't get myself in trouble. So I'm being talking roughly around it like my attorney told me to. So I'm following his advice so I can go home tonight without going in jail cell. Okay?
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
Ray Hartson, I do want to say that I think Mr. Evans is correct in the fact that because the respondent got up here and spoke to the committee for 2 or 3 or 4 minutes talking about various things, he should have had at least a chance to respond to that. And I think it did put him at a disadvantage. It was unfair to have that happen. And also, interrupting someone in the middle, with all due respect to the chair, is inappropriate, because people have what they're planning to say, and they're entitled to say what they say. Whether or not it makes any sense to anybody, it really isn't the issue. The issue is that this is their time, and they should be able to get up and say what they want in whatever manner they want to say it, and shouldn't be interrupted, and shouldn't have to argue with anybody on the chair about what, is this the appropriate thing or not the appropriate thing. They're doing what they feel is right. That's their responsibility. That's their obligation. And they have to live with the results. So again, I think he was treated unfairly in this matter in the very beginning, because they responded, was permitted to get up here and go, oh, well, I don't understand anything. They have an obligation as city employees to understand the Sunshine Ordinance, and if they're going to appear before the court, I think they ought to prepare themselves so they can get up and present themselves adequately and not complain that they don't know what's going on.
Thank you. Is there anybody else to present facts and evidence in support of the complainant?
Yes, I'm appalled. I am really appalled that the African American Arts and Culture Center is not here representing themselves. Or they think they're above the law? Is this individual thinks you're above the law? I care much for the girl, but I'm saying principle. I'm appalled that the city and county, because she's a commissioner, because she was appointed by Willie Brown Jr., that she has the right to above the law. They have the right to try to stop due process, to have the right to stop an individual to come up to speak by putting a restraining order on them. I had restraining order put on me by the Fillmore Center. I won that case. I'm wondering why he didn't win. Was it because she's above the law? They tried to do it to me again. It is really unacceptable that the city and county will let somebody that's being funded by them, to have somebody from the Arts Commission representing the African American Culture Center. Let me just show you something right here. I'm appalled. The reason why, the reason why I'm here is to show some parallels on what's going down in our community, like I said before, of the control system, okay? Now, you have here the Arts and Cultural Center that's due here, in my opinion, that has plenty conflict of interest with a lot of people that's here. Now, if you go, we want to know who's the board of directors there at the African American Cultural Center, first of all, okay? And when did they have their meetings and how they have their meetings? When the notices go out? You also will find out that with the Cultural Center, you have individuals that's on the board that's controlling not only right there at the Cultural Center, but that's controlling over here at More Magic, and that's also controlling over Elliot West is not even here. So how the hell are we supposed to get to the bottom of what's going down here when these individuals think they're above the law that can't even appear here? But yet they can file complaints against us that's coming to you and Board of Supervisors, having restraining orders, coming in them and getting us arrested. I'm appalled. I would clearly rest my case right now, but I will show you how there's so much conflict in our community with just those three groups that are there right now. And how we're intertwined, people's in board of directors, that in front of funding, but we can't get no clarity around here. And when we try to, they use their muscles. The Willie Brown clique, and all of that. That's unacceptable right now. Now how the hell are you going to have a commissioner that's an executive director of a community think that she can't come here and answer questions because she clearly followed instructions from somebody that's in law to follow a restraining order against a community activist. That's not just following against him. It's following against me and others that's been working here for 20 years that have not got a dime from the city and county. Don't have no payroll.
Thank you. Is there anybody else here to present facts and evidence in support of the complainant?
My name is Dan Solberg. I'm pastor of St. Paul's Lutheran Church. I have worked with Randall Evans for a number of years. We have together formed and shaped a nonprofit corporation under which this particular request, the San Francisco African American Unfinished Agenda Corporation. You'll notice that the letterhead represents that organization, which is a legitimate nonprofit corporation. That corporation, seeing the need to acquire information about the community, began asking and has made a formal request of the African American Arts and Arts Center to have information. It's a simple request. There is no teeth in it. There is no guile in it. There is no desire to somehow upset the system. It is simply a request for information. Inasmuch as that there has been a total ignoring of such a request by those in administrative positions for that organization, not even a peep of response demonstrates, I think, a rather substantial arrogance. I find that to be sort of the undoing of any kind of sense of privilege, inasmuch as this is a simple request. Jurisdiction has been resoundingly attributed, but it's just simply one institution, one individual asking another institution for information. What is more simple? What is more straightforward than that? It's when you get those folks who are with arrogance and with a sense of privilege, who refuse that. We have a breakdown in the kind of culture and the kind of community that is desperately needed, particularly in the film world. It's just a simple request. Doesn't seem to be anything more than that.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Excuse me, sir. Mr. Evans, please be silent.
I think what I'm going to say is that when I was dealing with LFL Hutch and their services towards homeless people, they ran the worst homeless shelter. They ran the worst homeless shelter in the city and county of San Francisco. I mean, continuously cold, kicking clients in the heads. I mean, just threatening gang violence towards the clients. In this here, what they're talking about is the members not showing up, or if they're here, they're showing up late. Just a total refusal to supply documents. I mean, it really leads me to think that they have no respect for the members of the community, and they don't have respect for this body. So, I mean, I think y'all should demand some respect.
Thank you. Is there anybody else to present facts and evidence in support of the complainant?
Hi, my name is Tina Collins. I'm an activist in the Western Addition. I also do a lot of volunteer for Mo Magic. Mo Magic don't be sunshine at all. But I've been on Cheryl for years, and she has helped my daughter. I have a 16-year-old daughter who would have been lost to the streets, but she's not lost to the streets. She goes to private schools. I have two. Excuse me, I'm talking now. Excuse me. I know.
The people in the audience will please be silent while the lady is speaking.
I have two other young daughters, 5 and 7. I'm a mother of 3 generations. My older daughter is 26.
Excuse me, ma'am.
Okay, can I go on?
Well, ma'am, you're not speaking to the issue that's before us.
I'm set to speak towards the issue that is going. Okay, I have 2 daughters that I have to take to outside programs, outside the Western Addition. That's 5 and 7 years old, because there are no programs here. Mo Magic cannot do programs no more, which Cheryl used to do before she became a Mo Magic person. I don't see why I have fought for 3 or 4 years for Ella Hill Hutch, for the African American Culture Center, and for other organizations to help young youth that are on the streets come into the programs. I stay at Plaza East. There's still young men still on the street. None of those organizations has did no outreach to get those young people into the programs. And I know a lot of people are going to be mad at me, but I don't care, because my thing comes first for the kids. I still have 2 more kids to raise, and I want to know, where is the programming? Where is the money at? Where is the programming? I have 2 more kids that I have to bring up in this community, and I want to know where it's at, because I'm studying going outside my district to get help.
Thank you. Is there anybody else to present facts and evidence in support of the complainant?
Hi. My name is Adrienne Williams, and I am here simply because I want to address this board because as I understand the definition, what the petitioner is asking for is information. I have an after-school program with no funding. So we all do our part in the community, but what is it the community expects and what should be given to the community? If these people are funded with taxpayers' dollars, and you request information, this is the United States of America, nobody should have the privilege, because of your connections, not to bring that information forward. And so as I understand the situation here, yeah, we can define who's doing what. I've been an activist in that community since 2004. And I think that one of the issues have been continuously is that money is put into different organizations in that community and it never filters down to the little people. I happen to have been funded by the city, and because I have demonstrated that a one-woman grandmother can take care of kids with or without funding, but my organization is transparent, and I think the issue here is, do the citizens of the Western Addition have a right to know where public funding is going? And so that's where I want to keep it on the level. I have disagreed with my man Randall on and off because not necessarily the knowledge in his head, but the presentation. So I'm asking you guys to listen to the words, because what he's asking for is what members of that community want. I was around Ella Hill Hutch when Lefty was there. I also know the situation that's going on in that community, and it's a struggle. It's a struggle to take care of the babies with no funding, but I do it every day. And so, but we have a right to know if you're getting public funding, where is it going? And so I think that's the issue here. Now, London is in the building. I just ran into her. But, yeah, she is. She's in the building. Yeah. So I want to keep it on the level that we stay with the issue. The issue is, do nonprofits who are receiving government money, do they have the right to conceal their books? Do they have a right to keep information from the public? And so I think that's the issue, and if we sort of overlook all the dramatics and stick to the issue of just releasing information, and I think the community has that right, and we're getting pretty frustrated in the Western Addition, seeing what's going on and not feeling like you have any recourse, that nobody's going to listen to you because you're a little person and you don't have the connections. So please keep an open mind and let's just stick with the issue, the right to have public information if you're funded by the city.
Thank you. Is there further public comment? Is there anybody else to present facts and evidence in support of the complainant? Seeing none. Is the respondent present?
I'm here on behalf of the...
Please step forward. Thank you for coming. Please identify yourself. You have 5 minutes.
My name is Judy Nemtsov. I'm a program director at the San Francisco Arts Commission, and I was asked to be here to represent the respondent. There are 2 issues that have complicated this matter. The first is that the initial request for information was sent to the wrong city agency. It was sent to Grants for the Arts, which is not a funder of the African American Art and Culture Complex. It was belatedly sent to the San Francisco Arts Commission, and so we need to clarify that as an issue. The second issue that has slowed things down and has made this more complicated is this issue around a restraining order. I am here to say that I have been asked by the City Attorney's Office to work with the organization to provide information as requested to the best of our ability, but it's going to take us some time to do that.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member
question.
Kaufman?
I have some questions for Ms. Nympha.
Nemtsov.
Would you please? Yes, thank you. Why didn't you give Mr. Evans the documents he requested?
I didn't get the request. The request,
When did you get the request?
I got the request a week ago and referred it back to the city attorney's office because of the issue regarding the restraining order.
So, are you a 12L organization?
I am a city agent. I represent a city agency.
We're talking, he wants the documents from the African American
Yes.
Culture Center.
But maybe it would be
Is
helpful
that a
if I...
12L group? Tell me what they are.
Yeah, why don't I take a moment to explain why I'm here. The San Francisco Arts Commission serves as both the landlord and the primary funder of both the building and the nonprofit that's housed in the building. So that's the African American Art and Culture Complex. It's one of 4 cultural centers that we have this relationship with. We do fund them through a grant through the Hotel Tax Fund. That grant amount is an annual grant allocation, and it does exceed the $250,000, so it would qualify under the 12.
Okay, so you have no objections to giving him the documents?
The information came to us very late. We are interested in cooperating vis-a-vis the city attorney's office to provide the requested information.
So you say you will provide the information to him?
Yes.
Okay. Now the question is, when someone makes a sunshine request, the information is supposed to be turned around in 10 days. Can you do that?
Well, we never formally received a sunshine request, which is what I wanted also you to understand, because the sunshine request initially went to the wrong city agency.
But you have it now.
I have not formally received a new sunshine request. I was forwarded the one that was sent to the wrong agency.
Well, the documents in the papers, what he wants is very clearly in the papers under his letterhead. So can you use that as the basis for it?
I can use it as the basis, and I can work with the city attorney's office to provide appropriate information.
We've got a couple of issues here. One, can you get him the information? 2, the issue of the city of restraining order. And can you please make that connection for us?
Well, the restraining order, and I have a copy of it, does not allow Mr. Evans to directly request information from Ms. Breed, who is the executive director of the Art and Culture Complex. So the city attorney needs to intervene here and has asked, as the lead city agency that funds this organization, to cooperate with the city attorney's office.
So what you're saying is you'll get the document, you'll give them to the city attorney, and the city attorney will give them to Mr. Evans.
Exactly, yes.
Can you get the documents to the city attorney in 10 days?
I can certainly do my best, make my best effort to do that. Yes, these are not my documents, these are documents of the nonprofit organization, but yes, we will work as closely as we can.
So you say you can do it?
I'll give it my best shot.
Okay, well then, but when did you get the request? You said a week ago?
I did not print out the letter, the date. I didn't print out that email, but it was approximately a week ago. And I just on Friday spoke with the city attorney's office. So if I'm a little bumbly, it's because I'm learning all of this as we go.
Did you respond to the city attorney's office or anybody saying you would provide the documents?
I just want to be clear, these are not documents that I have. These are documents of the nonprofit
You are
organization.
representing.
I am representing.
You are the liaison
Yes.
person, so therefore you're the spokesperson.
Yes.
So these are documents that you can get for
Yes.
Mr. Evans and give to the city attorney.
Yes.
But you're willing to provide all these.
I will,
How
yes.
soon can you provide them?
Well, as required by Sunshine, I will do it as requested.
Well, okay, then if you can get them to him as soon as possible, why didn't anybody respond to him though? See, when there's a sunshine request, you're supposed to respond to them and let them know that you'll give them to them at this particular time, or alternatively, that the documents are not public documents.
Right. I think that this got complicated because, it was originally sent to the wrong it was sent to the wrong city agency.
Got that.
And so then it was sent, then forwarded to me. I don't recall how much time went from that first document. And then got more complicated because Ms. Breed cannot respond directly to the Sunshine because of this restraining order.
Okay, but you're the spokesman, and I'm...
Yes.
As I
understand-
don't want to keep on repeating myself.
No, I
You're the
understand.
spokesperson, you're here to tell us that the request will be complied with as soon as you
I
can
will
do
work
it.
with the city attorney's office, and we will do our best to respond. Yes, absolutely.
Member Williams?
Okay, I would like to know, the restraining order, is it against the whole group is asking for it, or just Mr. Evans and Ms. Green?
Excuse me, Mr. Evans, please be seated and be silent.
I have a copy of a restraining order, and it's between Ms. Breed and Mr. Evans, but it includes he's not, as I understand, to communicate with her in writing in any manner.
Not even in writing?
All I can do, I'm not an attorney, I can give you a copy of the restraining order, and I understand from glancing at it, and from what I have been advised, that he is not to communicate in correspondence in any manner.
Now, who is Ms. Breed? What is her position?
She is the executive director of the African American Art and Culture Complex.
So who is the keeper of the records that would have this information?
Ms. Breed, as executive director.
Now, when Ms. Breed found this information out, couldn't she have just simply replied back to Mr. Evans that, I don't have the information right now?
I'm not an attorney, but as I understand, she is not required to respond because she has a restraining order against him. You're asking me questions that I don't know the answer to because
How
I'm
old
not
is
an
this
attorney.
restraining order?
Excuse me?
When was this restraining order taken out?
September 16th, 2008.
So that was after he wrote? Yes.
It was prior to, yeah, prior.
No, it was prior, it was 2008, not this year.
2008.
Okay, 2008.
Yeah.
If I may,
Member Craven Green.
it seems like we have two issues here. The first issue is that we now have someone who is committed to giving us information, which they deserve, and they should have received by now, right? So we have a commitment that that is going to happen, and information is going to be provided to the San Francisco African American Unfinished Agenda Corporation. I would suggest that if in fact there's need for a follow-up with the African American Art and Cultural Center, what issues of the legality and the appropriateness of the restraining order aside, that perhaps Reverend Solberg or Dr. McCrae could be the person submitting the information, because if it doesn't apply to those two individuals, that may be a way of getting around this. I'm just saying this is something to investigate that you can look into. Depends on the protective order or the restraining order that we haven't seen. However, I think we have a commitment here to provide this information. They're going to get this information to the members of the task force. What I would suggest is to refer this to compliance and amendments. And next month we have a meeting, or in 2 weeks we have a meeting, and find out, 3 weeks, excuse me, what's been provided, and if there are any disputes about information that hasn't been provided. And I think that would be the best way of getting this information, the quickest, the most effective way we can to get this information to the group that's requested it.
Member Kaufman.
I would just move to find the respondent in violation for untimely production, and note that they have agreed to provide the documents as soon as possible.
I wouldn't support
Excuse
that.
me, is there a second?
I second.
Moved and second. Member Craven Green.
I actually don't think I can support that, because we haven't figured out, Member Kaufman, whether or not it's a 12-level organization and whether or not they've exhausted the administrative appeal, which they have to undergo. 12L requires you to request, if you have a problem receiving information from the underlying contractor, right, from the nonprofit, to go to the supervising commission first. Isn't that correct? And we don't know if that's happened. And so I think instead of going into whether or not there's been a violation, because I don't think the technical steps have been met, let's do what we can to get them the information, right? That's the important thing here.
Mr. Evans was
Member
here last year,
Williams.
the same problem trying to get information. And this is what's happening. And I've been trying to tell y'all all along, this is what's happening out there, that they're not getting the information that they need, and don't nobody want to listen, but they need to get the information when they ask. But everybody bypasses a sense of an excuse, and me being an African American, I am really concerned about it, because I know what's going on.
I agree. I think we should get them the information, and that's the most important thing.
Yes, I mean, can I
Member Cawthon?
just say one more thing? Yeah, I would like if to the chair, if Vendor Craven could tell us what she thinks the stumbling blocks are. Because if we don't know if they're 12L and therefore qualified and therefore required,
And no,
what is the reason?
the testimony has been that they qualify as a 12L because they receive over $250,000. That is established. However, this is not my interpretation, this is the law. Pursuant to 12L, there's certain things people have to do. And in terms of requesting records, there's under 12L5B, there's a dispute resolution procedure. So a member of the public can request additional information other than financial information, which this one goes beyond the kind of information that has to be disclosed. They shall submit the request or complaint to the city agency department to the parties who administer the nonprofit's contract. Following such consideration and recommendation, the member of the public of the nonprofit organization may speak an advisory opinion concerning the request or complaint from the Sunshine Ordinance Task Force. So, in the past, we've interpreted that section to require a negotiation, to require a conversation between the person wanting the information and the city department that governs the contract. This is what we've required in the past pursuant to that provision. I don't see that having occurred here. Okay, so that's why there can't, in my view, be a violation yet. But, so that's why I would support a violation. Does that make sense? Okay, maybe our city attorney could do a better job.
Mr. 3?
That does appear to be a correct interpretation of 12L5B. It requires that if you are requesting information beyond some limited financial information, including the tax returns and other materials, that if you do not get that, you have to take your complaint about not getting that information first to the agency that's funding the nonprofit and allow them an opportunity to mediate that dispute.
But haven't she done that? Isn't the Art Commission the relevant agency?
As I understand the testimony, the Arts Commission is the relevant agency, but there's been no evidence presented that the dispute was taken by the complainant to the Arts Commission and that he sought from the Arts Commission a mediation of the dispute.
Could we just have the Arts Commission, Ms. Nympha again, please, up here, Ms. Nympha? You heard what they said.
Yes.
Do you have any objection to mediating it and getting the information to the appropriate party as soon as possible?
No, I have no objection. But I do want to say we were not formally approached by the plaintiff.
I understand.
Yeah,
I understand.
I was forwarded an email from Grants for the Arts, but yes, I am willing.
You're happy to be the intermediary and do what you're supposed to do so he can get his documents.
Yes.
Thank you. We really appreciate that. So I think it was untimely, but they're showing a good faith on the part of Ms. Nympha from the Arts Commission to be the middle person to mediate this. And I think we could simply have a resolution that there was untimely production.
There's already a motion on the floor.
Yeah, right. Vote on the motion.
Well, the motion, I believe, was to find a violation, was it not?
For untimely. And then note that the moving part intermediate, the Arts Commission has agreed to act as the middle, to act as the liaison to see that Mr. Evans gets his documents.
Okay. This time we will call for public comment, please. If you have already spoken, you may not participate in public comment. Mr. Hart, you have already spoken in behalf of the complainant, you may not speak now. Is there anybody who has not spoken who wishes to speak on this matter?
Good afternoon, Sunshine Ordinance Task Force, City Attorney. I'd like to speak on this matter because it has similar patterns to other violations that I've noticed. And that is you have one body requesting information and another body that has the information. And fundamentally, nobody wants to help the other side build their case due to the fact that giving out information that's unnecessary may do that. So each piece of information needs to go through a certain amount of hurdles to retrieve that information. And the value of that information depends on how many hurdles you have to go over to get it. And that is just the fact of the nature of the information age that we live in. Nobody is going to give you information to help you build any type of case that you can come in here and throw at any department or any government agency. And if you want information, you have to go about getting it in the right way. You may have to quote the statute or the local code that will enable you to get that information. But to say, I need this information, so-and-so won't give it to me, and, just get all frustrated about it is not really the answer. If the information's out there and you can show that you have a detrimental need to it, there is a process to getting it. It may be convoluted, but it's not a function of a broken system. It's just the fact that information is so valuable these days, and it can be misconstrued, that the city attorney's office or the public entity is not just going to throw it out there in a casual manner. It's got to be gotten, and it's got to be procured in a diligent and timely and effective manner. Thank you very much.
Thank you. Further public comment? Seeing none, the matter is back with the task force. Is there further discussion on the motion? Member Creighton Green.
I just want to explain why I don't support the motion, but why I want to do everything within my power to make sure the individuals who requested the documents get them, and get them soon. Because it's already been more than 10 days since they requested. In a perfect world, or a world that was in compliance with the ordinance, if someone submits a request that can't be complied with because there's a one department, they're required to help. They're required to forward it to someone to get that information. That needs to be done. If someone sends a request for information to a 12L, that 12L information is not provided by that contractor, by that nonprofit, then unfortunately there's this, I think it's a hurdle. I don't necessarily agree with it, but it is the law, unfortunately, that the requester then has to make a complaint to the commission or department that supervises that contract, which was not done here. Perhaps because Mr. Evans didn't know about it, perhaps because it's an arcane and ridiculous burden, but it is the law. So what I want to do, I'm not going to vote for the motion to find a violation because I don't technically think legally there has been, but I want to get this information to the people who deserve it. And so that's why, if this motion fails, I'm going to recommend to the chair that this goes to Compliance and Amendments Committee in 3 weeks. I want to see the Arts Commission in there, having provided information, everything they can, to the people who requested it.
One final comment. I think that the complaint should go to the Compliance and Amendments Commission for follow-up, no matter how this motion is voted on. And I think it's a lot, and since I'm not a lawyer, I think it's a lot simpler that there are a lot of moving parts here, but the essential thing, as the gentleman said, is they asked for the information, it's available, they didn't get it in the 10 days for whatever reason, so it was untimely production. The Arts Commission representative has kindly offered to be the intermediary and see that he gets it, and I would commend her for that. But I do think that we should move this along and send this to CNA, the Compliance and Amendments Committee, and then let it take its course. So I move that we vote on this.
Okay.
Call the question.
Question has been called.
Call the question. What is the question?
How much time are we gonna give them to let them have this information?
Okay, well, actually, there is one final step here that I apologize for not having taken to this point. At this time, we will give the respondent and then the complainant. Respondent first, and then the complainant, 3 minutes each to present any concluding or rebutting remarks.
I just want to assure the task force that I will work to facilitate the communication and the appropriate materials. Again, I'm happy to work with the city attorney's office and provide the requested documents in as timely a manner as we can.
Thank you. Mr. Evans, you have 3 minutes.
First of all, is all this being recorded?
Yes, it is.
So I want you to point on record, turn number one, never did ever we not misdirect this information. I purposely made sure that Reverend Solberg signed the letter. I purposely made sure that Ace Washington took the document straight to London Breed and her place of business. I don't know why you want to disbelieve her and not even take the time to understand what I'm trying to tell you. I've been doing this for 34 years. I am a master community activist. Ever since 1964, I've been in this business doing this stuff, okay? And I don't have no problem at all being very clear when it comes time to dealing with the government guy. When I have a problem is that when I stay here all this time, and folks like you, nothing personal, man, sit up here and just think you know that you can outthink what everybody else is saying. Just believe her. I don't know where she came from or who she came from. We never sent anything to her office because I wasn't trying to get no information from her. And at this time, legally, I don't believe you're going about the process right. So I'm making sure it's recorded. Technically speaking, here's how it should go. This is an organization we have. It's called the San Francisco African American Unfinished Agenda Corporation. I'm the founder. Reverend McCrae's involved in it. Reverend Solberg involved in it. And on this particular issue, because it was legality involved, and it's not a restraining order, she didn't give you a copy of anything, but yet you want to believe it. She didn't show you anything. I came to his office and showed him documents. You're a main man. I gave him every document, so you have it. And what the document says that I can go to where she go to the commissioner's office. I can even go to her building. I can communicate with her. My corporation can do that. She's not fair, and it's not fair for us as a community. Look at it, the big picture. Black folks try to get something busy. Now you're going to make me sound like I'm a criminal. I've sat here and told you before, I put one of my feet in the penitentiary. And I'm innocent until you prove me guilty. Since you've never seen no documents, I'm upset. I'm pissed off. Because I go through a lot of time and trouble to get this information, and then you sit up here and say, oh, well, darn it, we're going to make sure he gets it now right away. That's not how it goes. You know, it's unfair. And you need to do your homework and ask the right question. He got all the information. Every bit of everything I had, he has it all. So for you guys to sit there and say, well, I don't know if it's passed right, then why don't you read the documents like the other speaker said before you come and get me all worked up? I don't think it's fair. This is my moment right here to do the right thing. I've done everything I'm supposed to do. I haven't threatened the lady. I haven't disrespected her. I've been arrested. I've been put in handcuffs at the commissioner by merely making mistakes. They told me they had warrants on me, get me downstairs around the corner, say, oops, mistake. I don't come up here bitching and moaning about that. I roll with the punches because it is what it is. When somebody gets up and tell you something that's not true and slander me, I'm a businessman, and she slanders me. What do you think the other younger black folks, my son is in this audience, what do you think he thinks about coming up here? If y'all believe what the other folks say, just take a deep breath and remember we got a black president today too. We could be right.
Thank you. The matter is back with the task force.
Point of order. I am the one that delivered that letter to London, personally, with my initial on it. It was to London Breed, the president. So if you want to call me as a material witness, this lady here, I don't know, like here, where she come from? This is what we're showing you how people overuse their power. Through the city attorneys, I am the one that delivered it to her.
Okay, Mr. Washington.
And he has it on record,
Mr.
with my
Washington.
initial on it.
Through the chair, if I speak a little bit.
Member Craven Green.
I just want to make one point, hopefully it clarifies things, maybe it doesn't. The ruling of this task force that 12R, I would say, my opinion, put it that way, that 12L has not been complied with has absolutely nothing to do with whether or not there's been a restraining order, whether it exists, whether it's legal. It has nothing to do with that. This has to do with the fact that under 12L, You have to go, if you don't get information from a contracting nonprofit, you have to go to the commission that oversees it first before you can bring the sunshine complaint. That's the problem. And I don't like that requirement, but it exists. And I'm sorry that it's arcane, but that's the issue. So the issue of the restraining order has absolutely nothing at all to do with the ruling, at all, or who got the request. Nothing to do with it. I'm sorry.
Can we read the motion, please?
Read the motion and then we'll take a roll call, please.
The motion is to find an untimely production of records and to agree to send the matter to the CAC.
What section of the ordinance?
57.21.
And against whom? Just for clarity, I'm not supporting.
We'll figure that out later.
No, what? No, against
No.
whom?
Against whom? We have to do that now. Who violated?
Who violated?
African American art and culture.
No.
Ms. Breed.
Okay.
Ms. Breed. Ms. Neff, are you still here?
Yes, sir.
Who are you representing?
I'm representing the African American Art and Culture Complex.
Okay, so they're the ones. They're the ones that Ms. Breed works for, right?
She's the executive
Okay, we've got it. Thank you.
They got to her.
May we have the roll call, please?
On the motion, Member Craven Green.
No.
Member Craven Green, no. Member Thornton.
Yes.
Member Thornton, aye. Member Washburn. Member Washburn excused. Member Knebber.
No.
Member Knebber, no. Member Johnson. Member Johnson excused. Member Chen.
Aye.
Member Chen, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
No.
Member Chu, no. Member Nee.
No.
Member Nee, no. Mr. Chair, we have 4 ayes and 4 noes.
Okay. Both parties should be apprised now. This matter is not concluded. The task force has agreed that even though we do not find violation at this moment, the complainant still has the right to the information that he is seeking. The respondent has agreed to provide him with that information. This matter will be calendared at the Compliance and Amendments Committee meeting, which is to take place 3 weeks from today. Both parties are advised to appear there and give us a progress report on whether the information is being provided as requested, and if not, why not.
The date is October 13th.
I'm sorry.
The date is October
The date of that
13th.
meeting will be October 13th. It will be, the meeting will begin at 4 p.m. It will be held in room 406. Ma'am?
I will actually be out of town. May I send a representative from the Arts Commission in my place?
Yes, that representative should be knowledgeable on the matter at hand, fully apprised, able to answer all of our questions.
Do I have to be here? Can I send a representative as well?
That's up to you.
I'm gonna do the same thing. Hey. Rob.
At this time, the chair will declare a 10-minute recess. Mr. Clerk, could you read the next items, please?
The next item is the hearing on the status of the January 6, 2009 order of determination of anonymous against the San Francisco Police Department.
Okay, Mr. Rustin, if you'll recall, please, items 21 and 20 through 24, where are we taking next?
Okay, Mr. Chair. Item number 21 is the determination of jurisdiction filed by Peter Warfield against the clerk of the board for alleged unlawful and unjustified redaction.
Okay, before we begin, item 21, I have a request from Mr. Warfield to continue items 21 through 24. He had to leave. Without objection? Items 21 through 24 are continued to our next regular meeting, which will take place 5 weeks from today. Okay. We have received a complaint, we have received a request from excuse me, Mr. Adachi?
Yes.
Could you approach for a second, please? Which item were you here for?
Good evening, Commissioners. I'm here on the matter of, I believe, Randall Evans, Mr. Evans, concerning low magic.
Okay. And that is, those are items number 13 and 14. You have requested, sir, that these items be moved up now? Is that correct?
Yes.
Okay. Is there anybody in the audience who would object to these items 13 and 14 being moved up?
Yes, I object.
Okay, please approach.
Dave Curdo, Director of Contracts, Human Services Agency, for items 9 and 10, and we've been bumped all afternoon.
Okay, thank you.
Rita Flynn's item 8, it's already 7 o'clock, and I would prefer not to be bumped.
Okay.
Ray Hartz, and I was the two next items on the agenda, and I do not request, or I request you do not bump us.
All right. You see, Mr. All of you see, sir.
I also would like not to move other items ahead of item 8, I believe it is.
All right, all of you see what we're up against here. Everybody, Mr. Evans?
The reason, I don't know how he just asked you to do it, but the thing is that More Magic gave me what I needed before I got here, and a big mistake was made. They're not really asking me pumped up. I don't have no issues with them. It's LL Hutch and the Culture Center, and it's making up, messing up my relationship.
Okay, sir, are you saying you're withdrawing your complaint then against
More Magic don't have to even come up, they can go.
Okay, so items 13 and 14 then are withdrawn. Those complaints are done.
Thank you.
Mr. Adachi, thank you very much for coming, sir.
It's been an education, thank you.
To say the least. Well, it's very unfortunate. We have a long agenda tonight. We've had a lot of complaints. We try to accommodate people, but it's not always possible because there are so many requests. Member Coffin.
I think that people who are patient and long-suffering suffer under a policy where people who ask get to go to the head of the line.
It's not always possible to accommodate everybody's wishes. We do our best. And Mr. Clerk, you call the next item, please.
The next item is item number 6, the hearing on the status of the January 6, 2009 Order of Determination of Anonymous against the San Francisco Police Department.
Okay, I believe, is Anonymous here? Okay, please approach the microphone, sir. And before we start, I would ask the clerk that the complainant has already identified himself here. He is no longer anonymous, in which case it is preferable, I think, to list him by name as complainant.
In the order of determination, the complainant was identified as anonymous, and that is a public document.
Okay. Do you wish to remain anonymous at this time? If not,
No, I said that a long time ago.
Please identify yourself then, and you have 5 minutes.
Thank you. Again, my name is Ray Hartz, and I was very, very pleased this morning when I went to the City and County of San Francisco Index of Public Records to actually see a listing from the police department. So, after a year of struggle, we have finally managed to get the police department up to where all of the other departments are, which is still out of compliance. If you go to look at what they've done is they've put the retention schedule on there. They basically didn't put a listing of everything. What they did is they put the big long list, and if you go to the list, it says you're going to keep this here for 2 years. We're going to put this over here for 5 years. There is still no way for the public to use the index for which the ordinance clearly states it's for, is to help identify public documents. So again, I still would be in the position of having to struggle with the San Francisco Police Department to get a copy of policies and procedures. Because all it says in there is policies and procedures. I would imagine the San Francisco Police Department has a lot of policies and procedures. And then I would have to get into the fight again of, oh, which procedure do you want? What's the number? Yada, 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 yada. What I said before, and I will repeat again, is if all of you will go and look at the City and County of San Francisco Index of Records and read the Index of Records section of the ordinance, you will see that almost no city agency is in compliance. Because all they really have there is a listing of documents, some of which turn out not to be true. My case against the Arts Commission, where I asked to see a copy of their human resource policy, and we went through around and around and around and around, only to have them say, we don't have it. Well, why not? It's listed there. Well, because we did this, we did that. The purpose of the Index of Records is that I, as a citizen, want to look at something that I feel is a public record. I should be able to go in there and look it up. Just like I go to the public library and I go into the computer and I look a book up under the author or the title or the subject or something like that. And the idea there is to help me go forward, get the information I need to do the things that I'm there to do. And I think it is really, really a clear indication, and this is something I'm going to be taking up with the Police Commission. It is a clear indication to me that the City of San Francisco has no effective civilian control of the police department. Office of Citizen Complaints has sent a report to the Board of Supervisors basically saying that if they want to give us information, they give it, and if they don't, they hold it until the statute of limitations goes away, and then they can't do anything about it. I've approached the city department of the San Francisco department, and I told you I'm going to start doing this on a regular basis, going to individual departments, district offices, and I'm going to ask for information and see how much of a struggle we still get. This is an ongoing battle, and we have only, after over a year of struggle with this particular complaint, managed to get them up to the point where they are just as out of compliance as all the other city agencies on that index. So what do? File another complaint? Go through the process again? I would hope that the Education and Training Committee, with working with them to do this, would have told them, well, look in the law, and it will tell you specifically what this should include. And apparently that wasn't done. Although I've said it several times. If you go to look at the index, go look at the index. Just go look at the index. Read the section of the law that applies to the index and see if any of those agencies are in compliance. And if you're going to work with them to help them get in compliance, then get them in compliance, not just somewhere in the ballpark.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent here? Thank you for coming. You have 5 minutes.
Good evening, Commissioners. Lieutenant Daniel Mahoney, head of the Legal Division. Mr. Hartz is correct. It is the Index of Records is up. I was able to get it up, as you know, after the last meeting. It went up about 2 days after. Just for a point of clarification, as you know, the Index of Records is a working document. It's not something that goes up and then we forget about it. So it is being reviewed periodically and updated as necessary. Furthermore, just so you're aware as well, and I believe you are, the template for the Index of Records was provided to us by the City Administrator's Office, and our Index of Records that we sent in had to go through City Attorney review and approval before it could go on the website. And it did. It passed all that muster. So as I stand here today, the Index of Records is up on the website. It is a working document, and it is constantly under review.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
I have a question.
Member Chu.
How did this get on our agenda? I mean, is there any concerns that from what I understand, this was referred to EOT. Is there any concerns that EOT has that why it's here? What are we discussing?
Member Coughlin.
Just a follow-up. And I would like to commend Lieutenant Mahoney for not only getting this done, but also for being a very patient and a very patient guy with a lot of resilience.
Member Craven.
I don't remember if she wasn't at the meeting, but there was some concern about the timeline that it was taking the department to comply, and EOT said that they had no problem with the chair placing it back on the full agenda, and that was what was done.
Okay, I have no concerns. And I think we should close this matter as soon as possible. Both this one and the next one.
Member Craven.
I mean, the only thing that I would suggest is I think the department has complied. I think the city administrator is the place that EOTF would want to go next to determine whether or not the form that the city administrator is giving departments for compliance with the index of records is sufficient, if we believe it's sufficient, or if the form that the city administrator is using can be expanded to provide more detail to people requesting records. So I agree that the matter is concluded. I appreciate the Police Department, Police Commission for getting it done. I particularly appreciate Mr. Hartz for pushing this matter, because but for him, it would not even be there where it is today. So I do appreciate both sides working on it. I think if anything else needs to be done, it's EOTF looking at the website, looking at what the city administrator requires, and perhaps working with city administrator to make people update their indexes of records and providing additional information.
Is there public comment on this matter at this time? Seeing none. At this time, the respondent and then the complainant will each have 3 minutes to make any concluding and rebutting remarks.
Submit, Chair.
Mr. Chair, for the record, I'm Lieutenant Riley from the Police Commission. I'm responding here on behalf of the Commission.
Thank you. Mr. Hartz?
With all due respect to Lieutenants Mahoney and O'Reilly, if I have the names correct, I'm bad with names, terrible. There's one thing that changed about my personality to be that, although most of you probably think there are other things you would rather see change. As I said, it took 10 years to get to the point where they have met not even the minimal requirements. They said they passed it by the city's attorney's office and passed muster. I don't know what exactly that means. Did it comply with the ordinance? Or did it just, there wasn't anything the city attorney could find to raise an objection to? I really don't know. What I do know is, having gone to the index, and I would submit to each of you, go to the index, look at it yourself, and see if you could really locate a public document in the possession of the San Francisco Police Department or Police Commission using that document. And I would submit you can't. And I can start filing complaints. I can start one a day. I can go down to each one of the city agencies and I can file a complaint against it, and we can go on and on and on and on and on and on and on. Because that's where I see these policies going. I hate to disagree, and I'm not going to trying to raise this, but I don't think the police department deserves any pats on the back. It took them 10 years to obey the law, and they had to be dragged kicking and screaming to do it. And I don't know why everybody seems to feel that a citizen of the city of San Francisco should be nice when city agencies fight them tooth and nail and use city agencies and city time and city money and city effort to withhold documents from the public, to fail to comply with the law, and just drag it out and drag it out and drag it out as long as it can. That doesn't deserve an attaboy. If I was working for someone and it took me, I was given a year to do something and it took me 10, you think I would have been there 10? After the year, I would have been gone. But again, this may not be the time or the place. I haven't decided yet. I will start filing complaints. If you want one a day, we can just have 5 or 10 or 20 on every agenda. And I'm not doing this to be nasty. I'm doing it because this is just not working. No citizen should have to go through this process to get city agencies to follow the law. They are the law. If anybody should follow it, they should.
Thank you. Task Force? Is there any motion? believe the matter is concluded. Thank you both. Mr. Clerk, can you read the next item, please?
Item number 7 is the hearing on the status of the February 24, 2009 order of determination of anonymous against the San Francisco Police Commission.
Complainant?
So, this doesn't necessarily have to be a hearing. I mean, we could simply get any additional information we've never heard before from each of our people and then conclude the item. So this is, unless there's new information to be provided.
If there is new information provided, we can put it back on the agenda at that time.
Okay.
Or we can, we can advise that a new complaint be filed.
No, I'm just trying to make this process a little bit, never mind.
No, this matter is concluded unless new evidence comes forward.
Number 7 is concluded also?
No,
No, I'm talking about number 7.
Oh, 7. Now we've just started number 7. I'm sorry. Please proceed, Mr. Hartz.
Again, on this one, I'll be honest, it's gone on so long, I really don't know where we are at this point. I think I filed a complaint which indicated that they were out of compliance with the index of records section, which includes having certain defined material in the website. And yet I'm hearing, as on the last complaint, that because they met some minimal requirement which nobody has really bothered to discuss, we're going to now say that the matter's concluded. And I'm saying in this case, as in the last one, they're still out of compliance. Simply because I put up something does not put me in compliance. What does the ordinance say? The ordinance says that it should be a useful index for the purpose of the citizens of the city of San Francisco to research and obtain public documents. And under no stretch of the imagination will what they put up there satisfy that requirement. And to say that because they put something up, we're going to just conclude the matter is really just ignoring it. And everybody sits there and reads their papers and looks at their computers and does everything but make eye contact. That's one of the things I've noticed about city commissions. Very few people will look you in the eye. They'll do everything but look you in the eye. That's city government as a whole. Like most of the people who come in here and represent the city. We're doing the best we can. It's too much trouble. Maybe we'll give it to them if they promise not to ask for anything else. 10 years. 10 years, good times, lean times, and there's always an excuse not to give the public the information they want. They're not in compliance. They are not in compliance with this section of the ordinance. The simple fact that they put something up is not compliance.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, respondent, please.
Members of the task force, good evening. I'm Lieutenant Joe Riley, as I stated earlier, appearing on behalf of the San Francisco Police Commission. When this complaint was first filed, we immediately produced an index of the records we maintain in our office, turned those over to the department, which had the ability to post these on the website, as Lieutenant Mahoney indicated. Work with city attorneys, or city attorney and the city administrator. We have now done so the matter is up. I'd just also like to say for the record that in my 5 years as Secretary of the Police Commission, I've never failed to produce a public document when requested. The department's general orders have been online, available online for a number of years. They're out there. Very pleased to report that our index of records is out there. As a matter of fact, I just amended it and added another category to our index of records and gave that to Lieutenant Mahoney for posting on the website. And I'll submit on that, sir.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter with the task force. Mr. Hartz, please approach the microphone. Okay, item 6 is concluded. We're focusing strictly on item 7 now, which is against the police commission. Are there any records that you know of, resident within the police commission, that are not indexed, that do not appear on the city's website, on the commission's website?
What I'm saying is it's not an index. It doesn't tell you any specific document, it just lists clumps of argument like general orders. And then it's simply, you click on it, and there's a link to nothing except a sheet that says we keep it on-site for 2 years, we keep it off-site for 5 years, and this is the person you contact. That's it. And then you still go through the same rigmarole of what document do you want, what's it called, what's the article number, what's the page number, what's this. But you can't figure any of that out without an index. There is no index. That isn't what it is. It's simply a listing of when they destroy certain documents. That's all.
Thank you. Lieutenant Riley? Give us a little bit of an idea of what's on the index, please.
The index that I submitted, sir, Index of Records to the Police Commission Office. Item 1, agendas and notices. Item 2, minutes. We have minutes bound going back into the late 1930s, I believe, late 1930s. Number 3, audio, DVD recordings, audio recordings and DVD recordings of meetings. Number 4, commission meeting files. Now, our records are driven chronologically. Since the commission meets every week, we necessarily categorize things by the actions taken in a particular meeting. So that's the basis of our index, of our record structure, is chronological. Item 5, general correspondence. And that all correspondence to any commissioner, to the office, anything that we send out under the signature of the commission president. Number 6, disciplinary files. Some of those are in fact confidential under 832.7 of the Penal Code relating to police officers. Number 7, general working files. And that would be any projects, any issues, any legislation, any positions taken by the commission on any matters within the jurisdiction of the police commission. Number 8, records of meritorious and police commission commendations. These are medals of valor, other recognitions that police officers have received over the years. We have those going back to the 1920s. Number 9, rules and procedures, administrative and disciplinary records of patrol special officers. Since they're not police officers, their disciplinary matters are in fact public. And that is the index of records that I have submitted.
Okay, let's take it a little further now. You mentioned you have minutes and agendas of commission meetings, is that correct?
Yes, sir.
Okay, so if I click on that particular line, agendas and minutes, that takes me to a listing of meeting agendas and minutes, right, by date?
Yes, sir.
And if I click on one of those dates, that'll bring them right up?
Yes, sir.
Okay. How many, the complainant says that if you click on a line, all it's going to do is give it a general idea, a general description of what's on there, and you have to go to this office or that person to get the actual information. How much can we actually get through, just simply through the index of records? What's going to take us directly there to where we want to be?
I don't believe that the index of records is itself linked to the database, where you can pull up our agenda, where you can pull up our minutes. Within the police department's webpage, there's a commission webpage. On the face of that is links to agendas, to minutes, et cetera, et cetera. And then we have them going back, I think, online to 1997. The index itself, I can't speak to the structure of the index because I don't have the capability of controlling that portion of the site. But I don't believe that the index itself is meant to be interactive, but it is rather a list of available documents.
So if
I'm guessing.
So if I click on documents and it gives me a list of documents about thus and such, and I decide to click on, there's a list A, B, C, D, E, and I click on E, it won't take me to that document?
I do not believe so. I'm not sure if the index of records is interactive or not. What I'm referring to is a list of the documents that we maintain that I turned over for inclusion in the index of records. It lists what our billable records are. If you want to see those, You roll over to the commission webpage, and all the links are there.
Okay.
That's my understanding of the way it works.
Thank you. Other members? Any motions? In that case, the matter is concluded. However, I would urge that the Education, Outreach, and Training Committee continue to monitor this, continue to work with the department and the commission.
Okay, Chris, could you just put this on our agenda for next time?
Okay.
So maybe in a couple of months.
We've neglected to ask for public comment on this item. I
Okay,
apologize
thanks.
if there's any.
Just so we don't forget.
Any member of the public who wishes to speak on this item? Seeing none, public comment is closed, and I believe that concludes the matter. And I would ask Mr. Hartz and the gentleman from the police department and the police commission, please continue to provide us updates on what's going on here. This is a matter of great concern to us, not just with the police commission and the police department, but with all departments. We want to make sure that the index of records are thorough and that they're current. So, thank you all for attending. Mr. Clerk, could you read the next item, please?
The next item is the hearing on the complaint filed by Rita O'Flynn against the Mayor's Office of Housing for allegedly deleting email records which were the subject of a Sunshine Ordinance request for record.
Thank you for coming, Ms. O'Flynn. You have 5 minutes.
The Mayor's Office of Housing conducted lead abatement on my property in 2005 under a lead hazard reduction grant program. In January of 2007, during the course of an eviction, we notified the Mayor's Office of Housing and Writing of our intent to opt out of the program and return the funding if we were successful in evicting the tenants at 1672 Great Highway. And I provided you a copy with our letter. It's Exhibit 1. The tenant we were attempting to evict is well known within City Hall, was president of the Sunset District Democratic Club, and was a San Francisco commissioner. At the owner moving eviction hearing in March of 2007, Myrna Melgar-Iton of the Mayor's Office of Housing testified that the Mayor's Office of Housing never received our opt-out letter. This is provided to you in Exhibit 2, the sworn testimony of Myrna Melgar-Iton, specifically page 265, lines 17 through 20. In March of 2008, I requested an opportunity to review the files for 1672, 1674 Great Highway. I also requested for copies, and I picked those copies up. And at home that same day, I noticed a considerable amount of the communications that I had reviewed at the Mayor's Office of Housing was now missing. Missing communication included extensive communication between the tenant at 1672 Great Highway and Melgar-Iton regarding grant qualification, relocation, and politics. Specifically, there was an email from my tenant to Melgar-Iton where she stated she could claim her grandson plays in front of our second freestanding property so that additional funding for this project could be obtained. I've made repeated attempts to get these emails from the Mayor's Office of Housing. In December 2008, in response to a subpoena to the Ellis Act eviction, Melgar-Iton of the Mayor's Office of Housing produced our opt-out letter of January 2007, which she previously denied receiving under penalty of perjury. With this, she produced an unsigned response or demand letter from the Mayor's Office of Housing, dated February 26, 2007, requesting repayment of the grant funds. This is Exhibit 3, Michael Palmer's response letter to Margaret Flynn, dated February 26, 2007. It's important for the Sunshine Ordinance Task Force to understand that this response letter, this alleged response letter, was dated prior to Melgar-Iton's testimony at the owner moving eviction hearing, where she stated under penalty of perjury and under oath that our opt-out letter was never received. Melgar-Iton further stated in her response to the subpoena of December 2007 that the Department of Technology restored all of her deleted email and that there were no additional documents regarding 1672, 1674 available. This is provided to you as Exhibit 4. The Department of Technology, however, has provided me with documentation that states that they have no record of any requests for restoration of email from the Mayor's Office of Housing or of any materials provided to the Mayor's Office of Housing. And this I provided to you as Exhibit 5. The Mayor's Office themselves confirms that they made no written request for backups of deleted email as stated by Melgar Eitan in her response letter to the subpoena. And this I provided to you as Exhibit 6. Based on my request for the restoration of records that I believe had been inappropriately destroyed, the Sunshine Ordinance Task Force issued an order of determination on the 1st of April of this year, indicating that the documents that I was requesting should be restored and provided to me. I do think at this point it's important that the Sunshine Ordinance Task Force be aware that my tenant in this issue is being represented by the Tenderloin Housing Clinic, a non-for-profit legal aid organization which receives a substantial portion of their funding from the Mayor's Office of Housing, and that Melgar Eitan made a personal referral of our tenant to the Tenderloin Housing Clinic for free legal representation. This I provided to you as well as Exhibit 7. Most egregious, and what really surprised me, quite frankly, was evidence provided to me by the Mayor's Office of Housing just 2 weeks ago, September 11th of this year. Specifically, the Mayor's Office of Housing provided me with emails from Michael Palmer regarding 1672, 1674 Great Highway that were not part of the file of 1672 Great Highway when I reviewed it on site, nor provided under any of my Sunshine Ordinance requests to date. This email is an email from Michael Palmer to Myrna Melgar Eitan, dated February 14th, and has an attached draft letter, demand letter. It should be noted that neither my husband nor I have ever received any of these demand letters in the mail or via the Sunshine Ordinance, and I request that you make the determination that the Mayor's Office of Housing should restore the emails at their costs, that they should be redacted by an independent third party who is not biased. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the complainant?
I have an item in 19 and 20, but I can't wait anymore, so can we continue to the next time?
Request to continue items 19 and 20.
I believe that is the two items. Is that the Lewis Dillon?
You're Mr. Dillon?
Yes.
Okay. Without objection? Okay. Items 19 and 20 are continued. Thank you, Mr. Dillon.
Thank you, Mr.
Sir, are you here to present facts and evidence in support of the complainant?
Yes, I am.
Okay, thank you. Please proceed. You have 3 minutes.
Thank you. Good evening. My name is Mark Wolfman. I'm Maria's husband. And first off, I'd like to thank you for your time, as well as members of the public, like Mr. Hartz.
I assure you it's a labor of love.
I can see it. So, Rita really covered this quite well. I was hoping to just step up here and cover any items that she may have missed. She covered it very well. The situation here is that we've been trying to obtain emails that the Mayor's Office of Housing has claimed have been deleted from their email system. So we proceeded with requesting information from the Department of Information Technology. And that matter was brought in front of this committee, and it's my understanding that the committee agreed that she was entitled to those emails. However, it was advised that we bring a complaint against the Mayor's Office of Housing in order to be able to compel production of those and have a determination made as to who should be responsible for bearing the costs of that reproduction. I think from my understanding of the last hearing here, there was some question from the committee as to what evidence exists as to whether or not emails have been deleted or not. And I think that if you take a look at the exhibits that were presented to you, there's enough evidence there to show that emails have been deleted. Specifically, an email from Michael Palmer to Myrna, which was Exhibit 8 of the package, included a copy of a draft letter that was supposedly sent to me informing me of my obligation to repay the grant funds. And that letter was sent to Myrna Eiten Melgar prior to her testimony in the trial, when she claimed that she had never received a letter from me, claiming that I was planning on opting out of this obligation to continue to rent our property. So I would hope that this is enough evidence for the committee to find that there are deleted emails that we're entitled to receive. I would hope that the committee would see that the Mayor's Office of Housing is responsible for bearing any costs associated with the retrieval of those through the Department of Information Technology. Thank you.
Thank you. Is there anybody else here to present facts and evidence in support of the complainant? Seeing none, respondent?
Hi, Oliver Hack, Mayor's Office of Housing. I'm not actually really sure what I'm responding to here. What is it? It's still that they allege that they came, they saw emails in a file. When they requested the copy of the file, there were no emails. They still allege that. Tonight we have a little bit more about what those emails might have been, but it's really still their word against ours. I'm here to say that, as far as I understand it, there were no emails that were deleted from the file.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Craven Green.
I have a question for Representative Flynn. On page 1 of your letter, you indicate that towards the bottom, I made repeated attempts to get the missing information from MOH. However, I finally received a letter from Douglas Schumacher indicating that MOH considered 1672, 1674 Great Highway to have been completed 2 years before my requests. Records were destroyed in compliance with the written record-keeping policies. When was that letter received? I don't think we've seen that.
It was received in May of 2007. Excuse me, 2008.
May of 2008.
Yes.
And was that before or after you reviewed the files?
After.
And so this is why you believe that, this is one piece of evidence as to why you believe that emails had been deleted.
Yes.
That you had seen.
Yes, and now I'm convinced that there were emails that never were in the file for me to
Now, you
review.
just restricted the questions. With respect to this Palmer email that you just received on September 11th, what was the context for the production of that email? Was MOH responding to a different request? How did this come to you?
Actually, I was kind of surprised. It sort of came to me from Mr. Hack. He said, this may be an email that you didn't have. So there was no specific request for this. It was just provided.
Okay. Mr. Hack? Can you please explain the context of you providing this email?
Well, she did actually request those emails. She requested all emails between certain parties, and one of them was Michael Palmer in regards to her property. And when I got asked or assigned to deal with this, I went and asked Michael Palmer if he had any emails on his computer, and he said, I have these. So I sent them on.
Okay, when was that request submitted to you?
I don't think it was that, maybe Ms. O'Flynn knows, it was not a few weeks before, a week, I'm not sure exactly when it was.
Okay, so as far as you know, there was a recent request made for emails regarding Michael Palmer specifically, and therefore you went and searched Mr. Palmer's emails? Or you asked him to search?
That's right.
And what did you ask him to search for?
Any emails regarding the properties in question that met the criteria of her request.
Okay, and do you know if that email that was received by between Mr. Palmer and Ms. Melgar Eaton. Do you know if that email is still in Ms. Melgar Eaton's email?
I don't know if it is or not.
Okay. My final question for you is, records under the mayor's office record retention policy, administrative records regarding contracts and grants are kept for, are records that are kept by the city. They're considered records and are kept for the term of the grant, I guess, plus 4 years. What is your, the grant that's underlying 1672, 1674 Great Highway? When did that, is that grant still active? When would that expire?
It was 2003.
It was 2003. And then the work was done, however, in what year?
2005.
The work was done in 2005. So records regarding that should have been kept, it looks to me, until 2009. Under the mayor's record retention. Is that accurate?
If that's what it's saying in front of me, it's accurate.
All right, thank you. Ms. Flynn? Can you please explain if you submitted a recent request for emails, or what the request for Mr. Palmer's emails are that led to the production of this email?
Yeah, I've been requesting email actually all along, and so I was actually made a request for email from a more recent time period. This email, though, from Michael Palmer is clearly from 2007 and should have been provided to me back in 2008 when I started to make my original requests, A, for the files, and then specific sunshine requests for all the emails.
Right, and that, I don't have it before me because I know we dealt with this with the Department of Technology complaints, but the request for emails, can you briefly describe to me what that was in?
I requested all email regarding 1672, 1674 between various members of the Mayor's Office of Housing and my tenant. I believe I also requested any that were included to Fiona Ma.
Right, and was Mr. Palmer listed?
Yes, absolutely.
He was in there. Okay, thank you. Thank you. That's all the questions I have. Members, I don't know if anyone else wants to ask questions, but this has been a long and drawn-out process. I mean, the issue here is that what we needed from Ms. O'Flynn was proof that there were emails that she did not receive that had been deleted, because that's what we were missing. She said that she had seen emails when she went in to inspect the records. When she asked for copies, those emails were no longer there. And we needed some specificity and some proof to be able to hang our hat on, because we didn't have anything to be able to find that the Mayor's Office of Housing may have violated their own record retention policy or deleted emails that were subject to the sunshine request. It looks like we have some proof to that effect. In the Mayor's Office of Housing, this information's in our packet, and there's been no response from the Mayor's Office of Housing to explain, you know, what's going on here, or rebutting her proof, specifically the Palmer email that was recently produced, that was not produced from Ms. Melgar's, the original packet of information produced. I'm not sure how the Mayor's Office produces their information, but I know as a law firm, when you do discovery requests, you keep a copy of what you produce, so you can say, oh, that was included in the original production. We don't have the Mayor's Office of Housing saying that this email was included, and this may be one of the emails that, in fact, was deleted. So I think, in fact, now we have proof. The Mayor's Office of Housing, because this is dealing with pending litigation, may not want to put anything in writing. That's probably what their strategy has been with respect to this situation, because this is, as I said, ongoing litigation. But from my perspective, we now have proof that there were emails which, as I read the Mayor's Office's own record retention policy, should have been kept for 4 years after the term of the grant. So not only through the term of the grant, but then for 4 years in addition. And it seems that we had a situation where those records were deleted. And so I will think about what motion should be brought. but that's kind of where I am.
This time, we'll take public comment on this item. Seeing none, public comment is closed. At this time, the respondent and then the complainant will each get 3 minutes to present any concluding or rebutting remarks.
We believe we have given all of the emails that we have pertaining to this case to Ms. O'Flynn.
Thank you. Ms. O'Flynn?
Thank you. I'm hoping that the evidence that I presented to you here today will not only show that there's been some problem with the email, but also with other communications regarding my property. I do think it's important to remind you all that there is, as you brought up, there is some litigation based on demand letters, which were never received by us in the mail, nor provided despite repeated Sunshine Ordinance requests for the materials in the file. Thank you.
Thank you. The matter is back with the task force.
I remember I think Mr. Hatch is fairly new to the department, is that what you said when you were here last time? So subsequently, I do believe Ms. O'Flynn did see something at that time and didn't get the copy. And for some reason or another, it appears that something has been deleted, and I don't know just what we could do about it. Because you can't bring up something that we don't have, and they can't make up something. Mr. Hatch can't make up something that they don't have in the records. You can't produce it, so I don't know where we're at right now. It seems to be in her favor that she did see something, and for this last evidence, but Mr. Hatch can't produce an item that's been deleted. He hasn't seen since he's new to the office, and I believe he's telling the truth.
Well, I think there are some issues here. Number one, in terms of deleted emails or other kinds of records, usually before they are deleted, they are backed up. So they must be available somewhere on a backup medium. Second, there is Section 67.29-1. Records survive transition of officials. All documents prepared, received, or maintained by the office of the mayor, etc., are the property of the city and county of San Francisco. The originals of these documents shall be maintained consistent with the records retention policies of the city and county of San Francisco. As Member Craven Green has pointed out, the destruction of these emails may have violated the mayor's office's own policy. 67.29-7, correspondence and records shall be maintained. It doesn't say paper correspondence and records, it just says correspondence and records. By that we can I think infer that electronic records also are included in this. So I think if a violation is found, or more than one violation is found, it would then be up to the mayor's office to contact the Department of Technology, make every reasonable, diligent effort to recover the emails that have been deleted and requested by the complainant, and to be prepared to report to the Compliance and Amendments Committee what those efforts have, what if any fruits those efforts have borne. Member Craven Green.
I would move to find a violation of 6721 for failure to produce requested records, and 67.297A, failure to maintain records as required by the city's administrative code and the mayor's office's own record retention policy. I believe the mayor's office of housing should be directed to have Department of Technology restore the email records of Ms. Melgar-Eiten, only Ms. Melgar-Eiten, because that's the only one we approve of, that there are emails missing that haven't been returned. For the specific time frames and terms requested by Ms. O'Flynn in her original request, and the cost of that restoration and review should be borne by the mayor's office of housing.
Is there a second?
Yes.
Second. Several seconds. Further discussion?
Are we going to give them a certain time limit
Yes.
to do this? Okay. Thank you.
Further discussion? Roll call, please.
With respect, just with respect to the
Members
question,
of
the time limit, this is a complex.
Yes, it
If
is.
the mayor's office of housing is going to comply with order of termination, which we'll have to wait and see if the motion passes, this is a complex procedure as to which the Department of Technology will have to, as we've heard testimony from the Department of Technology plans and amendments, pull up all the email time frames, restore it, back to Lotus Notes, Arcade. It takes time. We want to see them. The first issue is, are they going to comply? That will be the first test, and that will be discussed at compliance and amendments.
Roll call.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn excused. Member Kneba. Member Kneba, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Nee.
Aye.
Mr. Chair, we have 8 ayes.
Thank you. Thank you both for attending. It's been a long evening. We appreciate your patience. Could you read the next item, please?
Item number 9 is the determination of jurisdiction on the complaint filed by Hannah Loom and Lydia Fong against the Department of Human Services for allegedly withholding information.
I move we find jurisdiction.
Moved and seconded to find jurisdiction. Is there any public discussion on jurisdiction? Seeing none. Any comment by the task force? Seeing none, roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn. Member Washburn excused. Member Kneba.
Aye.
Member Kneba, aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Nee.
Aye.
Member Nee, aye. Mr. Chair, we have 8 ayes.
Okay, that takes us to the merits. Thank you for coming. Please identify yourself. You have 5 minutes.
Thank you, members of the task force. My name is Hannah Leon, and I'm one of the complainants. My business partner, Lydia Fong, is away on vacation today. I just want to provide an update on the status of our request and follow up with 2 brief comments. Since the filing of the complaints, and it's been several months, we have recently received substantial documentation from the Department of Human Services, and I do thank them for providing those. They substantially comply with our request. There's a few exceptions. We did ask for certain accounting records. They did provide a list of all properties sold with the bid dates and the court dates. I have not decided whether we want to pursue additional accounting records at this time. But I also have a couple of comments. They have provided letters that were sent out to the parties that we initially requested in August. And my comment was that at that time when we appeared in front of the task force at that time, I suspected there were additional records, and I felt that looking at the totality of the circumstances, it would be reasonable to think that there would be additional records. However, the task force felt that I was not able to prove that something that was not in the file, and it was difficult to prove since I am not in control of the file. So now that we have, at this time, having the production of the certain documents, it did show that there were correspondence that was sent out at the time when we requested, the production, and they were not produced at that time. But now we have received substantially most of what we wanted. That was purported to be the entire file. Whether that is true or not, I do not know. However, since that was mostly what I would like to see, so that's my update on the status. And I also, I guess one last question was, in the August hearing, we had not a full board, and we did receive 4 votes, and that did not carry the motion for violation. And I guess my question would be, would I have a right, not that we're going to do it at this point, but would we have a right to request the same issues to be considered with a full board again? I guess that's just my question, and those are my comments.
Thank you. I think it's appropriate to respond to your question at the time. If you have any new evidence to bring to it, then certainly we can consider bringing it back.
Thank you very much, and I think at this time at least it concludes mostly what we requested, and I'll try to work with Mr. Curto and see if we need additional information, and hopefully we can work it out. Thank you.
Thank you. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, respondent, please. Thank you for coming. Please identify yourself. You have 5 minutes.
Yes, good evening, Chairman D, members of the task force. Dave Curto, Director of Contracts for the Human Services Agency. As Ms. Leung said, she has made several requests for productions of documents. We have tried to comply with them. We did have an ongoing procurement process, so there were certain documents like the proposals from some of the non-awardees and the people who ultimately have been awarded could not be released until the Adult and Aging Services Commission made those awards. Once they made the awards, we released all the documents we had. And I will admit there were some other documents, such as we have some logs in there of what documents we have that we produced the second time that I did not produce the first time, nor did I produce any of Mrs. Leung's her documents, because I assumed she already had them. So I think we've worked all of that out. She did request financial records, and we produced what financial records we had. A little bit of history: the Department of Adult and Aging Services came under the Department of Human Services in a merger of the 2 departments in fiscal year 2004 and 5. One of the reasons that happened was, one, for budgetary reasons, but number 2, the Department of Adult and Aging Services was deemed as unauditable by the Controller's Office because their records were in such disarray. We have created some of them, but I will admit that some of the requests for production of documents that extend back 10 years beyond that period, we simply don't have. So we've, in good faith, we've tried to provide Ms. Leung with every document that she's requested. And I think, as she said, she has substantially everything that she has asked for at this point.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter for the task force. No comment from the task force. Member Craven Green.
Well, my only comment would be it's unfortunate it took so long to get compliance. It's unfortunate that someone has to file a complaint to get the documents. And would hope that in the future the department would move more expeditiously to provide the documents that are releasable, understanding that certain documents are exempt until awarded. And I just wanted to appreciate the persistence of Ms. Leung and her partner for continuing on with the request, and hopefully it's been resolved in the working relationship going forward in a more productive, efficient manner.
At this time, we'll ask for public comment. Is there anybody who wishes to comment on this matter? Seeing none, public comment is closed. Is there a motion? No motion. The matter is concluded. Thank you both for coming. Mr. Clerk, will you read the next item, please?
Item 11 is the determination of jurisdiction on the complaint filed by Randall Evans against the Ellicott Hutch Community Center for allegedly not providing documents under Chapter 12L.
And once again, members, I move that we find jurisdiction on this item.
Second. Moved and seconded. Discussion. Is there any public comment on the matter of jurisdiction? Seeing none, public comment is closed. This is strictly on the matter of jurisdiction, whether this qualifies for handling by the task force. Okay, seeing none, the matter, the public comment is closed. Roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Member Craven Green, aye. Member Coffin.
Aye.
Member Coffin, aye. Member Washburn. Member Washburn, excuse. Member Knepper.
Aye.
Member Knepper, aye. Member Johnson. Member Johnson, excuse. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Lee.
Aye.
Member Lee, aye. Mr. Chu, we have 8 ayes.
That takes us to the merits. Mr. Evans, please approach the microphone. Again, thank you for coming, sir. You have 5 minutes.
Elliot Hutch has been in a turmoil for quite a while, been involved with it far back as that before the system was built. Since this last group of folks actually took over, there's been no respect whatsoever. To me, I can't even see how the place is being ran. Unfortunately, we're not here just to get information. We're trying to figure out a way to save the center and be a part of it. But whoever's in charge of the folks that's dealing with it, somehow they don't read their bylaws, they don't have meetings, they don't give up information, they're not here now, and they don't care, they're just arrogant, and this is the results of it, I just regret that these same 3 organizations are just 10 minutes away from each other. I've been here all night, and it's just the same group of folks that we're dealing with to get information with. Culture Center, Magic, other Hutch, they're all the same people. All Townsend, it's the same folks. So we're just trying to get information, see what's the problem is. Got no help, no success. Thank you.
Thank you, sir. Is there anybody here to present facts and evidence in support of the complainant?
I'm back again. First of all, I wanted to say that this has been an experience. If you noted, when I first came in, I brought my babies down here because they are the ones who have been impacted by a lot of the things that have... Can you not do that right now? Please. I brought the kids down because I wanted them to see that there was a glimmer of hope for them, that there is some place in the city of San Francisco, a board, an oversight that hold people accountable. I've invested a lot of time in this community because I wanted to save the babies. And one of the things that sometimes you're fearful that if you say something, you voice something, you're going to be retaliated against. Well, they've taken my funding, so I think I can speak freely. And I wanted the babies to see that there is recourse, and I am so happy that this was my first time before you guys. I see how the process worked. It has given me a glimmer of hope that when we see something wrong, when we see something, and I've taught them, historically, we're known throughout the community because we sing the National Negro Anthem, Lift Every Voice and Sing. And I've been trying to instill, these babies come in an environment where it's so much violence. And so you've seen on the news where murders go unsolved because people are afraid to speak. I had to take the babies home, so I missed an important part of this meeting. I came down, as I indicated before, I know that in Randall's heart there's sincerity. As I said, it's the presentation. But I've never been fearful because I want to teach the kids that you have to strive to be right, even in adversity. Now Ella Hill Hutch was good to me and my family. My grandbaby is now 10 years old, my daughter is 30. She came through Ella Hill Hutch. So I have a loyalty to that community. When we got no funding, I did not shut down. I did not skip a beat. People can tell you that I've taken care of these babies throughout the summer. We've had the best summer because I was able to galvanize
the community to support us because they know how sincere I am. But what I'm here before this board to say that these three organizations are interconnected. If you look at their board, each and every one of them, and I was disappointed that I missed the Mo Magic section because there were 2 items in that section that I was hoping would be revealed here today. I think financial statements, if you're a public entity, should be available to the community. And I can remember when Ella Hill Hutch a few years ago was in turmoil. Everybody that came down from the city, they assured us that they would be accountable and that there would be transparency. But what I've seen is nepotism, cronyism, and the same set of people are...
Please conclude.
Okay, the same set of people are in control, and the money, I'm here representing the little people. I want to see in the future that when there's public funding given for kids programming, that is not given to a brother or sister, that is not given to a mom, it is not given to your best friend, that that money is used for the babies. So that's why I brought the babies down today. That's why, in spite of the expressions here, I took the time to come down today. And I'm pleased. I'm so pleased that you guys exist and that there is recourse when you see injustices being done. Thank you.
Thank you. Is there anybody else who wishes to present facts and evidence in support of the complaint?
Yes, I am here again. I'm just floored. I'm just appalled that agency has been in our community for over 26 years to think that they don't have right or shouldn't come here before you with the arrogancy. I would just like to say I'm thankful that we have this board, and I'm on Channel 25, and that's why I'm documenting this so I can show that there is a process, there is a place where people that have a problem could come here. I'm here also for reform. This type of thing will also lead to reform in our community, because I'm not here to point the fingers at nobody, but we need reform in our community, without a doubt. And the only way we can get that is collective accountability. And the only way we can get that is obviously here. So we're asking for your help, and I don't know what's the next step here, but it does seem like Ella Hill Hutch seems like they're above approach again. And then my diagram that she has, it would clearly states that those 3 agencies that you mentioned are intertwined with people that's on the board on all 3 of them, and to answer to no one. So I will close with saying I'm glad that you guys are here. We're here at 8 o'clock, but something needs to be done. I don't know what the process is of when you have people come to testify and the agency that you're talking about don't even show up. I mean, that's totally in violation.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, is the respondent here? Okay, let the record show that the respondent is neither present nor represented. The matter is with the task force. Member Williams?
Yes, I just wanted to say, Mr. Washington, you've been on the news reporter run for a long time with President Obama, and you're now in the, and we need you to put this, we need your card for your newspaper. We don't have, you have a newspaper, because we are trying to educate people that there is sunshine. So I'm so glad that you came here tonight and stayed the complete time to actually see that what we are doing up here in Sunshine, I know you're at the Board of Supervisors all the time, so that you can use us as a tool to educate low-income and high-risk people and minority people that there is a recourse that they are come to. So thank you for coming tonight.
Member Craig Green?
Yeah, I was just wondering for Mr. Russell, did we hear not from anyone from the Ella Hill Hutch Community Center?
Through the chair, no, I did not hear that. I sent them a reminder yesterday.
Have you heard anything from them whatsoever?
Nothing whatsoever.
Does anybody know who the city department is that would be in charge of this contract?
I think I have a document in the packet that says it comes under the Human Services Agency, but their contract is below $250,000.
Ella Hutch is below $250,000?
Okay.
Not according to page 137 of the
Yeah.
packet.
137 is
137, for fiscal 2009-10, the amount is below 250,000.
But it's, these are payments, it doesn't say what they've been awarded.
The remaining balance.
They've been, yeah,
Oh, I see.
600,000 remaining balance. So, right, I would be one to assume that they're hitting our threshold, without them here to prove they're not, right? This is, as the complainant notes, it's impossible to do anything when the respondents don't show up. It could be that HSA was not notified as well. Did we contact HSA, Mr. Rustin?
I did contact HSA and I was told that they are not responsible for it. They do not have a contract with the center.
So who does?
The website, I visited the controller's website and there was no responding agency.
So as we're sitting here today, we don't know who the department is.
Somebody's giving them
Would someone, would you please approach, ma'am, if you could answer this question?
We don't.
DCYF is one of their funds.
So you can talk to the microphone just so we can get it on record? Thank you.
I know that one of their major funders is the Department of Youth and Children's Services. But as you understand, they have multiple grants.
Right.
So I don't know who their physical agent is, as with the Arts Commission for London, but I know that they do get a major piece of their funding from DCYF.
Thank you. Well, I mean, we have a couple issues here. I mean, one of the issues is that if we can't figure out who their responding agency is, how can Mr. Evans or the other folks who are supposed to take administrative process up with them do that as well? I believe there's another individual here who would like to speak to my question. I would invite her up.
My name is Bernice Casey. I work with the Shelter Monitoring Committee. I'm an employee of the Department of Public Health. The Human Services Agency did hold a contract with Ella Hill Hutch until some time ago. There was a shelter operating there. My suggestion to the council and to the member of the public is to contact the Office of Contracts within the City Administration's office. It's a link on the website. You can say what what community agency you have concerns about, and the Office of Contract Administration will tell you which city agencies oversee that contract. I think DCYF, and there's one other agency, and I can't think of the name of it right now, that has a contract with Ella Hill Hutch.
Thank you. Thank you very much for that information. As with the prior complaint, my concern is that these documents get produced, because they should be produced, and the group should have this information. It's kind of hard to do that when no one's here. We're not really sure which agency is going to bring them to task, because it is the responsibility of the department in the city of County of San Francisco to put them in line if they're not producing information. So what I would suggest is that Mr. Rustin, please follow up. I would suggest that Mr. Rustin follow up with the Ella Hill Hutch Community Center and also the Office of Contract Administration to find out who has contracts with this nonprofit, and to follow up with each of those agencies or departments. So if there's more than one, follow up with every single one and forward to them the request that was submitted by the citizens group. Hopefully someone will take the reins on this and get these documents produced, because they should have been produced. Will bring power to bear on the Ella Hill Hutch Center. So, I mean, I know that's not really a violation, because I don't know who we can find violated, unfortunately, here. But in order to get this done, I think Mr. Rustin can play a role in getting this information to the requesters.
Do we want to continue it, come back at it?
I would submit it, I would refer to the Compliance Amendments Committee, like we did with the prior complaint, and Mr. Rustin can let them know that when he contacts them, that this will be heard, and we want them there to answer.
So that's a rest of continuance.
And Mr. Russell, if you would go through Marie Sue or DCYF, somehow they have connection, each one of them know who funds each other, and some maybe if
Through the chair, I'll contact her.
Sue.
Could you spell her first name? How do you spell it?
Marie Sue, I think it's S-U, it's S-U, Marie Sue. She's executive director of DCYF, and they usually know who funds each other.
Thank you.
Through the chair, if at the Compliance Amendments Committee we're able to uncover that there may have been a violation or we're not getting compliance, we can certainly refer it back to the next full task force meeting, with the chair's approval, to find a violation at that point. But right now, we just don't have enough information, and the folks aren't getting their records. So I think the best way forward is to sheepdog this through the Compliance Amendments.
Okay, again, Mr. Evans, the Compliance Amendments Committee is to meet through 3 weeks from today. That would be October 13th. And we would hope that you would be able to attend, and we hope that the responding agency or agencies would attend. One other thing we might do is work with our administrator, Mr. Rustin. Once he gets the information on which city agency or agencies contract with Ella Hill Hutch, then you can go to those agencies and ask for their intercedence in getting the records from Ella Hill Hutch, similar to what we advised in the preceding complaint. Go to the city agency responsible, get them to intercede on your behalf, then come back to Compliance and Amendments Committee. Let us know what success or lack of success you're having.
Excuse me, Mr. Chairman, another place that you can go is to the comptroller.
I'm sorry, Member Williams? Another place you can go is?
It's to the comptrollers.
Controller's office.
They're the ones that give the money. If it's a city agency, they know. So that's another area.
Mr. Rustin?
Mr. Chair, the document I provided in the information packet is from the Controller's Office website.
Yeah, the financial statement, but that does not list the contracting agencies. Okay. At this time, we're going to ask for public comment. Seeing none at this time, we will allow Mr. Evans 3 minutes to make any concluding remarks.
I think it's time for me to go ahead and just try to spend some serious money, get a serious attorney. I'm so discouraged today, it's outrageous. I've came to you more than one time. It's over obvious, painfully obvious. I've given you documentation. Mrs. Calvin, is that her name? You speak so elegantly, and it almost sounds like you know what you're talking about. In my opinion, you scare me, because the way you respond to what you hear, it's like you don't even have a clue. Shame on you. But for that matter, you can, guys, look at me. I'm 52 years old. My family go back 114 years in the Fillmore area. I was born right there in Fillmore, 52 years, and it doesn't take a rocket scientist for me to try to get you to figure out that if he not only gave me the opportunity to meet him, he's made quite a few mistakes, but he just started it, so I'm not mad at him, but he's done made kind of mistakes that had me on the wrong complaints. I believe it's his job, not mine. Once I do my part, and I go serve the folks the paper, I go to the board meetings, which are not board meetings, and then there's some kind of way they're supposed to have a policy, and this is a city agency through the Dwayne Jones office. I don't need to go anywhere and find out. I know what's going on. These same people. Look at what happened with Commissioner Bree. You were convinced that I got a restraining order. You were convinced that this lady was right. You were convinced that I didn't file something right. You gave me suggestions like I don't know what I'm talking about. I'm just discouraged here today. I do hope, I'm not just going to go to the H, I'm going to go to the news. This is a story. This is a conspiracy. People are stealing and throwing money away. A shelter got knocked out the box by Ross right there in that community. A shelter in the black community.
Hell, every one of us are such that show, and it's gone. And now we're trying to get you folks to get on top of it, and now you don't know who to get. So in other words, even if this was on TV right now, and we haven't sat down here till 8 o'clock at night, Elliot like said, the hell with it, we ain't coming, and you guys say, okay. So there's no repercussion. What about the ethics committee? What about y'all doing something, put some special committee together to service us? When we get to this point, trust me when I tell you, we don't ask as many times as we possibly can in the most polite way as possible at their board meetings, can we get information? They arrogantly treat us like nothing. Then we come, instead of violently doing it, because it's crime in those community centers, and people are dying right there in front of their lives. They're dying. Killing it. It's back and forth. That's the violent area. So instead of going in there raising hell, we come all the way down here, sit there all night long. Get back to the hood, and you guys say, whoop, sorry. That's not good enough, really. I'm not mad at nobody. There's an old saying they say out there in the hood, don't be mad at the players, be mad at the game. This game is awesome. It don't work. And y'all sit here, and you should be making some room for improvement. This is a black situation we tell you about, and it's really serious. We got a black president. We got no black leadership. I ain't ashamed to say Willie screwed up some stuff, and some of the people that are still involved even came here tonight. The reason why I let Jeff Adachi off the hook, because I don't want no problems with that department. I'm the only person in the community following these things to y'all.
Thank you.
Don't thank me. What do you mean, sir?
Is there any, does anybody wish to make a motion? Okay, seeing none, the matter will be referred to the Compliance Amendments Committee. Mr. Clerk, could you read the next item?
The next item is item 17, the determination of jurisdiction filed by Charles Spitz against the Shelter Monitoring Committee for allegedly not allowing public comment on an item at a recent meeting.
The members, once again, I move that we find jurisdiction.
Second.
Moved and seconded. Is there any discussion on jurisdiction? Is there any public comment on the matter of jurisdiction? Seeing none, roll call, please.
On jurisdiction, Member Craven Green.
Aye.
Aye. Member Craven Green. Aye. Member Cawthon.
Aye.
Member Cawthon. Aye. Member Washburn. Member Washburn excused. Member Caneva.
Aye.
Member Caneva. Aye. Member Johnson. Member Johnson excused. Member Chan.
Aye.
Member Chan. Aye. Member Goldman.
Aye.
Member Goldman. Aye. Member Williams.
Aye.
Member Williams. Aye. Member Chu.
Aye.
Member Chu. Aye. Member Lee.
Aye.
Member Lee. Aye. Mr. Chair, we have 8 ayes.
That takes us to the merits. Is the complainant here? Thank you for coming. Please identify yourself. You have 5 minutes.
There was a CD that I submitted. I submitted a CD as well, so I think that pretty much says the majority of what I'm trying to say here. I think the problem that I'm having is that is a lot of things with the Shelter Monitoring Committee is being pencil whipped shelter inspections, pencil whipped meetings. Just a lot of stuff going wrong with the Shelter Monitoring Committee. But my thing is
public comment on that? Is that an action item? On the runaround report, we not taking action. That's not what your agenda said. It said action. Discussion and action. And we did not take any action. There was no motion on the floor. There was no action taken by the body. There was discussion and no action. No public comment on that issue. There are other issues where we take action, and they will have public comment. There was only a panel public comment. That's not what your agenda says. Your agenda doesn't say that at all. I appreciate it if you follow your agenda. We're going to move on. All right, draft order report for you guys and
if you're hearing that he was definitely asked if he was going to follow the agenda, if he was going to follow the Sunshine Ordinance, not the Sunshine Ordinance, but if he was going to follow the rules and policies and procedures that go along with running a meeting, and he, it just seemed like he was very aloof. I'm going to assume page 151 in your packet, it pretty much says public comment will be heard before the proposed action. It seems like he just, Quentin Mackey, he didn't care. The Shelter Monitoring Committee, they just stood there like a band of thieves and did nothing. And now we're here before you today.
Thank you. No, questions later. Is there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Are you here for the Coalition on Homelessness?
No, I work for the Shelter Monitoring Committee. I'm a city employee.
That was the reason I asked. Go ahead, please.
As I said earlier, my name is Bernice Casey. I'm the policy analyst for the Shelter Monitoring Committee. In documents that I sent to the Sunshine Task Force on September 18th, I acknowledged after interviewing two committee staff members and two committee members and two committee staff that indeed Mr. Pitts was denied the opportunity to give public comment at the September 2nd, 2009 committee meeting. In a letter to Mr. Pitts on September 18th, I acknowledged this fact and extended my apology on behalf of the Shelter Monitoring Committee. I was not at the committee for this part of the meeting. At times, the committee members who have not received as rigorous sunshine training as they need make errors in judgment, and I'm there usually to correct them. Again, I apologize to Mr. Pitts that he was not provided that opportunity. What I did is send an email to all of the committee members urging them once again to watch the Sunshine Ethics training provided by the City Attorney's Office online. If they were unable to do that at their home computer, I gave them the opportunity to come in and do it. After speaking to Deputy City Attorney Jennifer Williams on the October 7th Shelter Monitoring Committee meeting, she will be reviewing the Sunshine and Ethics self-test that I've urged all committee members to complete beforehand. Quentin Mackey is no longer chair of the Shelter Monitoring Committee, nor a member at all. Henry Belton is the current chair, and Aram Hoslip is the vice chair. I took some time to review the Good Government Guide's rights of members of the public at public meetings with these two officers to make sure they fully understand that members of the public are able to give public comment after every agenda item, regardless if action is taken or not. And the reason that we have public comment at the beginning is so that members of the public can address anything that may not be on the agenda. Usually the committee members are a little bit lax about that and let members talk about multiple things throughout the meeting. And again, I apologize to Mr. Pitts that he was no longer able to address the issue of the turnaround report presented by Coalition on Homeless Jennifer Freetalk.
Thank you. Is there anybody here to present facts and evidence in support of the respondent? Seeing none, the matters with the task force.
I just had a quick question.
Member Craven? I'm sorry, Member Coughlin. My mistake.
On this case, I just wanted to thank you for your eloquent presentation. It was very clear and very easy to understand. But you're a passive meeting group, right?
Oh, I'm sorry. That's my other thing. There was a memo compiled on the 22nd by, I believe, Deputy City Attorney Threet. Actually, no, we are a policy body. The Shelter Monitoring Committee was created by Ordinance 147 point something in November of 2004. There's some of the sunshine rules that I would defer to you because you're the experts that we don't fall under because we're not a commission, but we do keep all of our minutes. We have an index of records. We do all of these things even though we're not required to do so. But we are a policy body.
Okay, I just wanted to make one pitch for my committee, which is the Education and Outreach Committee, and I'm very pleased that you're going to do some training. We also have a little training presentation that we made. In fact, we made one to the Mayor's Office of Economic and Workforce Development last week, so we're always available to come by and have some interaction and a Q&A and just hand out a pamphlet that summarizes everything. And so if you're interested, you could get in touch with our with Mr. Rustum, our administrator. We'd be happy to come by and do a little presentation for you.
Thank you, Commissioner. I'll follow up with Mr. Rustum and hopefully he could come in December. Thank you.
Ms. Casey, I just want to say, I saw you guys on television yesterday, and I saw your presentation, and it was just the same as it was here. You did apologize, and you were very eloquent, and you were very sorrowful that you made. And it was a long meeting, but I watched it because I knew Mr. Pitts was there. So I really appreciate you staying here this long. You have good spirit about you, and thank you very much.
Thank you. Thank you, Commissioners, for staying as long as you have.
At this point, we will take public comment. Okay, aside from the complainant and the respondent, the audience section is empty. So at this time, we will allow the respondent and then the complainant each 3 minutes to make any concluding or rebutting remarks. Ms. Casey first.
If you wish.
If you wish.
I have no comments, Commissioners.
Thank you. Mr. Pitts, do you have anything you'd like to say in conclusion or rebuttal?
Just have no faith that things are going to get better. Just no faith things are going to get better. They come here and see, go back out into the community and do whatever they feel like again. No faith. Quentin Mickey, he's been on the Shelter Monitoring Committee possibly 2-3 years. He's been very active in the community. If he didn't get some of the Sunshine Ordinance rules by then, I just wonder what's going through his head. I know he spent a lot of time on the committee playing with his iPhone, but Quentin and the new alleged chair, I don't think he can understand the concepts of Sunshine Ordinance and their implications, their rules. I don't think the new chair has any. I don't think he can comprehend it. I don't know if I'm going to pass on the insults, but no faith.
Thank you. Is there a motion? Okay, the chair will move to find the Shelter Monitoring Committee in violation of Section 67.15B, and the matter be referred to Education, Outreach, and Training.
Second. And Chris, could you put that on the agenda for the next meeting? Second.
Discussion?
And Mr. Pitts, don't give up. You are making a difference out there. I see you all the time out in the streets and on TV. So don't lose that hope. Don't lose that hope because you're fighting for a lot of people. I see you brought some homeless people here and they left. They left. They were behind you and so keep it up. You're making a difference. Every little bit helps. Okay? Thank you for what you're doing for the people.
Further discussion? Roll call, please. Oh, I'm sorry.
I just would like the order of termination to know that, that the Shelter Monitoring Committee admitted their violation and has agreed and to undertake further training and will continue to follow up with that training.
Okay, the maker accepts it, the second accepts?
Yes.
Amendment accepted. Roll call, please.
On the motion, Member Craven Green.
Aye.
Member Craven Green, aye. Member Nee. Member Cotton.
Aye.
Member Cotton, aye. Member Washburn. Member Washburn, excuse. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson. Member Johnson, excuse. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Member Nee.
Aye.
Mr. Chairman, 8 ayes.
Okay, Mr. Clerk, can you read the next item,
The
please?
next item is item number 25, which is the report on the Compliance and Amendments Committee on the meeting of September 8th.
Members, we had our regular meeting on September 8th. We heard updates on the status of the order of termination, many of which had been complied with, and some which had been continued. It seemed like most of the parties were working it out and hopefully getting the complainants all the documents they wanted. We will have some issues with order of termination. Peter Warfield against the Library and Board of Appeals. Neither of those bodies appeared. They submitted letters indicating what they wouldn't do in response to order of termination. As I said, there may be some issues to follow up with those bodies the next hearing as well. Both those items should remain on the agenda. With respect to the developing recommendations for the proposed electronic document retention policy, we're going to be proceeding with that. I want members to know that I have been invited by Richard Robinson, who appeared from the Department of Technology, who had appeared before the Compliance Amendments Committee, to a meeting at UC Berkeley tomorrow. That's going to take place with some members of the Department of Technology Public Policy, folks from the Law School of Bolt, the Samuelson Center on Information Technology, to discuss the issue of email retention more broadly and what San Francisco can do to facilitate public access and appropriate retention policies over in Berkeley tomorrow from 2 to 4. I think that will be helpful, and I will report back at the Compliance Amendments Committee and the next full task force on what was discussed. And then finally, in terms of the amendments, proposed amendments, Member Nee has submitted a number of typographical issues and proposed more substantive proposed amendments to the ordinance, which most of which I would say the Compliance Amendments Committee approved, and those will be, once Chris and I figure out the mechanics, will be categorized appropriately so that this full body can know what we've done with the amendments that have already been approved and how we've gone further. And I would encourage anyone else who has proposed amendments or any other cleanup items on the amendments to forward them to us for consideration at the next meeting. More?
Yes, I think it's a good idea to comment on something else that took place. This is on complaint number 09042, Peter Warfield. It was the library, public library. The Compliance Amendments Committee voted to continue that matter until the October meeting. That was not a unanimous decision. However, it was agreed at the time, it was noted at the time, that should the chair desire to put that item on tonight's task force agenda, The chair was empowered to do so. I did request that it be done. Initially, the draft agenda was amended to include that item, and for whatever reason, the item did not appear on tonight's agenda. This is, it's a regrettable oversight. However, from this point, we move forward as best we can with apologies to Mr. Warfield. Mr. Rustin?
Mr. Chair, that was my error. I made that error. How it happened was that after I had emailed you the draft report, I went and double checked with the CAC minutes, and the CAC minutes reflected at the very end that Chair Kramer Green had requested the meeting to be heard at the next meeting, and I forgot the part that where you said you wanted it. My apologies.
Thank you.
And that concludes my report, unless the other members have any comments. Seeing none.
Next item, please.
Item number 26 is a report by the Education Outreach and Training Committee meeting of September 10th.
Okay, as I said, we had a very good presentation before the Mayor's Office of Workforce Development, who had been Economic and Workforce Development, who had failed public records request. They were very, very interested. There were almost 40 of them. We thought that was a very good presentation. Doyle Johnson, Marjorie Ann Williams, and me. We're continuing doing outreach to people. We're also starting to we're trying to get place something in newspapers. We did have the case of Cawthon versus SFPL for public comment. The library did. I recused myself. The library did not appear, nor did they send a letter or a document. And I will let Marjorie Ann Williams tell you of what the committee decided to do.
The committee decided to write a letter.
Microphone, please.
The committee decided to write a letter concerning this.
Can I make public letter? Can I just not here?
I do not believe public comment would be appropriate for you.
Yeah, I just wanted to say that, I think it's very appropriate. We have problems with the library, and I think it's appropriate. In this case, they didn't, not only did they not show, but they did not even write a letter. And when the case came before the Fourth Task Force, you'll remember that they did not respond to Chris's request to appear. They did write a letter. So I think that Marjorie's suggestion that we write a letter and ask them what they're going to do, that it's not inappropriate.
I just want to say, I was sitting back looking at Mrs. Gomez and what the outcome. She was back laughing, and that really bothers me, but I want to commend the task force. We got more of this coming down the road. People are beginning to really know what sunshine is all about, and we are their last recourse. And now, as you can see, we're getting different types and status of people that are coming to us, so I just want to, I knew this was coming, especially with economic and workforce development, with how many minorities and women that they hire. We're going to start getting a lot of this, so we're going to have to be on our toes and be ready for this, because people are beginning to really trust us now. Say, we got, like this lady came here, I went to school with her. She volunteers, and she brought those kids down here to really let them believe. A lot of people believe they don't have any justice down here, and she brought these kids down here to let them see that there is justice. And I thought that we made a good impression on them, But sometimes I get, maybe some of you guys can work out in the street, but I'm out in the streets, in the trenches. And I know how it goes, and it's a hurting feeling when you got one or two people fighting against a lot of people. So if I've said anything, I did say because I'm African American, I know how they feel sometimes, how they're treated. They feel like they're just third-class citizens, you know, and nobody want to listen, so I do appreciate the board. You really were compassionate tonight, as always. But I see more of this coming down the road. It's more as we're gonna put it in the paper, you know. Our EOP chair wants to put it in every newspaper in the city, so we're gonna get more people coming to us.
Chair Neal, is that one final question? I don't know if it's appropriate for me to say it, but to the extent that what recourse do we have when a department has been found in violation by, it turned out, a 6-0 vote, and asked to go before asked to report on what actions they are taking to reverse that kind of behavior, and does not show it does not write a letter? What recourse do we have?
Well, ultimately, we have the recourse of finding willful violations.
Which we did.
I mean, if they, you know, I mean, if they continue their misconduct, then we can seek redress from ethics or city attorney or the DA.
I mean, is it appropriate to write them a letter commenting on the fact that they, for a second time, did not respond and did not appear? The first time they did respond in a letter, but they didn't appear. For the EOTC hearing, they not only did not respond when I first asked them to come, they didn't respond, they didn't appear. No letter, no appearance.
Okay. Member, I'm sorry, Member Money?
Yeah, so I know we've been here quite a while, and I'd hate to hold any of us longer. I just wanted to really underscore and supplement Member Williams' comment on some of the testimonies that we heard. You know, obviously a lot of these people are disenfranchised and come from much more blighted areas. And I wanted to share some of my brief experience in seeing and understanding their testimonies sort of a little more firsthand with work that I've done with incarcerated youth. From time to time, I volunteer doing writing workshops with incarcerated youth, and I know firsthand that a lot of these youth tell me time and time again that they have no hope and no faith, and they don't believe that there's an arena for them to participate in the discourse of expressing their their ideas, their thoughts, their feelings, much like we've heard from several of the people today. While a little more, I hate to say it's sensational, but on a lot of levels, it is justified because of their unfortunate experiences. So I think it's wonderful that I'm a part of this committee and that we are here to listen to what they have to say to the best of our ability, of course.
Thank you. Member Chan?
I just want to make a comment and Sue how she's, I guess the Education Outreach Committee is bringing more light to San Francisco and educating everybody about sunshine. And that's what we need. We need more, I guess, outreach and media. And that's the key focus and the key thing about getting sunshine or getting sunshine out there. And another thing is, and time again, I guess the public library is violating sunshine and blowing us off. We have no teeth. That's another thing. What are we going to do? We're going to write a letter? We're going to write a letter to ethics, right? And
what I would suggest, Ms. Coffin, the Education, Outreach, and Training Committee should have referred this matter back to the task force for tonight's meeting with a recommendation that we find willful violation and send it to perhaps the Ethics Commission or perhaps the Board of Supervisors. At this late juncture, I really don't think there's much that can be done. However, what you could do is at your next EOT, invite them to your next EOT meeting. Have the matter placed on the agenda for your next EOT meeting. Tell both sides you want them to appear. If there is failure on the part of the library people to respond and failure to appear, refer it back to the full task force with a recommendation for finding a willful violation.
I'm going to ask
Member Williams?
Because I need to be downstairs today. Jerry, if you...
Microphone, please.
You don't mind me asking you, I don't want to say it in front of the other people. When the lady got up and said that she had a restraining order, was we supposed to have a copy of that and see that? I mean, how did we
Okay,
really
I
push it?
think
I'm just asking him as an attorney.
Okay, I think you're out of order. I think we
Is
did
it?
it. Yeah. Right now, we're on the EOT report.
Oh, okay, I'm sorry.
So perhaps at the end of the meeting,
Oh,
Ms.
okay.
Williams?
I'm sorry, okay.
Does that complete your report, Ms. Goff?
Yeah, so what we will do, Administrator Rustin, just put it on the agenda, and we'll just go through the same process we did all over again.
Mr. Rustin?
Mr. Chair, through the chair, I'd like to remind Member Cawthon that the motion was to refer the matter to the CAC.
Sorry? Was that the motion?
That was the motion made by Member Johnson and seconded by Member Williams.
Did it pass?
To send it to the CAC.
But it wasn't sent. I mean, I was recused.
It would be for our next meeting.
That would be for our meeting on October 13th.
It's fine with me. So just go to CAC then instead of back to us.
Okay, but it would be helpful if the EOT committee would advise the CAC on the reason for the referral.
I think we've been advised.
Just to, you know,
Could you-
three weeks will elapse between now and then.
We
Send us a little note.
We're advising, we're referring it back to you because the library did not appear, nor did not appear or send a letter, nor did it appear at the full task force meeting on that issue, on that complaint.
Mr. Freed.
Yes, through the chair, at the subcommittee meeting, I had promised to have an answer for one issue that came before the subcommittee at tonight's meeting, and I have that answer if you would
This
help
is
it.
the EOT committee?
This is an issue about the printing of the materials, and the question was whether it was acceptable for the task force to print these materials with the city seal, and whether the personal funds of members could be used to pay for it, and the answer to both of those is yes.
Did you bring the card?
I did not take the card with me.
Yeah, this was Joel Johnson's project, and he is willing to spend the money to get a lot of cards printed.
Okay. I hope you use it as a union shop, but that's.
I think he did. Yeah, so
Okay.
when we finally get it produced, we'll bring it.
Okay. Does that conclude your report?
Yes.
Okay. Next item, please.
The next item is the administrator's report. I do not have anything to add besides what I have in the packet.
Okay. Is there any? The chair will note that the audience section has been empty for quite some time now. People ask 3 or 4 items. Is there any comment on the administrator's report by the task force? Okay, that takes us to any questions, answers, announcements, etc. Any announcements?
I would like my question to be answered.
Microphone, please.
Could she have shown us the paper?
Through the chair, whether she could show it to you is up to the task force, whether you want to see it. You could request it.
I do have a question. Mr. Rustin, you advised me before, when the agenda was being set about this restraining order. How did you become aware of it?
Mr. Evans provided me with a copy.
Mr. Evans provided you with a copy
Yes,
of the restraining order.
And he asked me to keep it under wraps. He says this is an issue that may come up, but I want you to be aware of it.
Well, he said it was an issue that may come up. Did he actually say that he was under a
He said
restraining
this
order?
is just between you and me.
Did he say he was under a restraining order?
He did not indicate, he didn't say anything, he just gave me the copy.
He gave you a copy of the
So I had to read through it.
So you know the restraining order was there?
Yes.
Okay, thank you. Further business, Member Chen.
Actually, I discussed this in the EOT when I was in the EOT committee. Is Sunshine should have a party. And like I said, I should go to the EOT and plan a party for Sunshine. Yeah, is that okay?
As long as it's, I believe, noticed, members of the public are invited, then it's fine.
I mean, of course, I mean,
But we have to notice it. You have to notice
Maybe
it.
we should have a party for Ernie Laurenti and invite the public as well.
I think that's fine as long as you notice it and invite members of the public. The question, I think, the retreat would be, would we have to do minutes of the party? I don't know.
I think social occasions, it's a social occasion, so you don't have to take minutes of the social occasion.
I
You
think
might have to
your
notice.
requirement is simply to notify the public.
Yeah, we did.
And it's open to-
Right there and invited the public.
And I can have spots for the party, so there's no taxpayers money.
Chair will entertain a motion to adjourn. Second.